Lord, may I be permitted to move an IA in a pending matter? There is an urgency matter.
IA in a
Pending writ petition.
when?
Today, madam.
Today not possible.
Tomorrow. It is-
The writ petition is
My
already
lord,
listed.
I'll just 2 minutes time I'll take. What had happened, my lord? In 2015, government of Assam came up with a rules whereby, my lord, Assam Land and Revenue Service was, constituted. And as per that rules, my lord, the cadre post of the service officers are, my lord, circle officer. Now, my lord, what the government is doing, my lord, in spite of the cadre post belongs to that particular service, my lord, members of the service are being appointed as circle officer attached. Now, service officer attached is a, my lord, ex-cadre post in the ACS Assam Civil Service. In the meantime, my lord, what had happened? In 2022, the Assam Civil Service Rule was amended, whereby it was said, and junior grade ACS officer will initially be appointed as either under secretary, SDO Sodor, or SDO Civil. And my lord, it was clearly said that in the meantime, since 2015 rules have come, that is the Assam Land Revenue Service Rule. Therefore, the civil service officers will not be holding the post of.
All right, but why can't it wait till 17th?
No, my lord, what had happened, a fresh order has been issued whereby 47 officers are sought to be appointed as circle officers. ACS officers are sought to be appointed as circle officers.
That's
All
what.
right, I can appreciate today, my lord. Tomorrow in the second half, if you not
Do you really think it can't wait till 17th?
17 Budvar. They might give, my lord.
They might.
They might give effect to the order which has been issued.
I leave it to you, but
Tomorrow.
I don't think it's a matter which can wait till Wednesday.
Or in the meantime, if there does something, Lordship will take care of that. In that case, on 17.
We'll see. If the case
Yes.
is made out,
Yes.
only then the question of interim order.
Yes.
Whether it's Tuesday or Wednesday,
Yes.
it's same thing.
Okay.
Wednesday.
Deeply obliged.
Lordship, I have filed an additional affidavit in item number 17, Lordship. And today, the registry may be directed to take the matter.
Yes, please.
May it please your lordship, with the consent of other side, I beg to mention item number 33, lordship. In this matter, we have to file our affidavit in opposition, lordship. Item number 33, lordship.
Yes, what do you want?
Lordship, 2 weeks time, lordship, to
You are
file.
for whom? You are for whom?
I am for Airport Authority of India, lordship.
Yes, for a number?
Yes, for number 1, 2, 3, 4. 1, 2, 3, and 4.
You have info?
I am for that phone number 7. I also need 7.
Any objection? The learned counsel appearing for the respondents have sought 2 weeks' time to file affidavit in this matter. Since the prayer is not opposed by the petitioner's counsel, same stands allowed. List the case again after 3 weeks. Yes.
Interim order will be continued.
4 weeks. The interim order passed earlier to continue until further orders. Yes.
Obliged, Lordship. Grateful.
May I please your lordship? Lordship, in item number 3 and item number 4, we have filed affidavits in opposition, lordship, as per direction of this court. Those affidavits may kindly be called for, lordship. Obliged, lordship.
But this same day affidavit calling will stop it actually.
We filed on Thursday and Friday, lordship. Obliged, lordship.
But I beg to mention for listing of a motion matter on Monday, this day, 17th.
What is the matter?
Matter commission department
Next Monday.
next Monday.
Next Monday.
Beg to trouble your lordship for 2013 matter. The matter was listed before this court on lordship on 11th. Due to paucity of time, the matter could not be taken up, lordship. I'll leave it to your lordship to fix a date as per your lordship's convenience.
Which matter?
It's an interstate seniority matter pertaining to the forest government, forest department, your lordship. The 2013 matter, your lordship. The matter was listed before this court on 11th. And due to paucity of time, the matter could not be taken up.
But some order has been passed fixing it. Check the order. Check the order and come back. Yes.
Yes, Your Honor. I am mentioning item number, I beg to mention item number 19. Senior counsel is out of station.
What do you want?
Kindly passable for the day and
As paid for by petitioner's counsel, this matter stands passed over for 4 weeks. Item 19.
19.
Yes.
My lord, for withdrawal, my lord, tomorrow, my lord.
Yes.
Me, please, your lordship, beg to mention for listing, my lord, writ petition. On Friday, my lord, there is some urgency in this matter.
What is the urgency?
Lordship, the similar writ petitioners have already,
No, that is not an urgency. What is the urgency in your writ petition?
Lordship, it's been pending, my lord, from long, my lord. Next week, my lord.
No, you make out an urgency, then only the,
Lordship, Lordship.
find out and come back tomorrow. Yes.
Lordship,
May I please, your lordship? I beg to mention item number 52. Lordship, my senior is out of station. Kindly matter may be adjourned for today, lordship.
You are for petitioner.
Yes, lordship.
On the prayer of learned counsel for the petitioner, this matter stands adjourned for 4 weeks. Yes.
May I praise the Lordship? Lordship, with the consent of the other side, I beg to mention item number 22, Lordship.
Hmm.
We are for the private respondents, Lordship. Lordship, today we have some difficulty. Lordship, matter will be taken up after 2 weeks. We have taken
On
the
the prayer of learned counsel for the respondent number.
Lordship, the private respondents number.
What is the respondent number?
Lordship, 3 and 4.
Respondent numbers 3 and 4. Made with the consent of the other side. Admission hearing of this matter stands adjourned for 4 weeks. Yes.
Lordship, I pray for listing of a hearing matter, Lordship, which is a 2015 matter, Lordship. Any day convenient.
You first approach the registry, then we'll see.
Oblige, Lordship.
May I please, your lordship? I beg to mention for listing of a writ petition for admission, your lordship.
Registry first. Yes.
May I please, your lordship? I beg to mention for listing of a writ petition for admission.
Same order.
May I please, your lordship, I beg to mention item number 27 from today's daily list as my senior is unwell, make
27, item
Yes.
27. You are for whom?
for the petitioner.
As paid for by learned counsel for the petitioner, this the
So kindly
admission
pass
hearing
it
of
for
this
the-
matter stands adjourned for 4 weeks.
And
May I plead your lordship? Lordship, in this case, lordship, the initial appointment of the petitioner was lordship assistant agriculture engineer. He was appointed in the year 1991, lordship. Thereafter, lordship, the petitioner has been promoted to the post of assistant executive engineer. And thereby, lordship, when the gradation list was published in the year 2019, his tenure.
So you are challenging OM dated 18/1/2020.
Yes, your lordship. Pursuant to
Other
this,
cases are pending.
Yes,
We'll issue notice and tag with the
Yes,
other case. What is the case number?
lordship, 363 oblique 2023, lordship.
36.
363. Lordship, in this case, whatever lordship, the writ petitioner has not impleted the other lordship aggrieved person who are also entitled for promotion, lordship. That is why lordship interim pair of the writ petitioner was not considered. In this case, I have impleted all the private respondents, lordship.
What is the interim prayer you have?
Interim pair, lordship, this so far the provisional gradation list that has been published by the authority, lordship. At this stage, otherwise, lordship, my seniority has been downgraded to rank
So
11.
as long as the OM dated 18/1/2023 remains, your seniority will be below. They have reversed the position
Yes, your
and stay order to OM 18/1/23 has not been granted. So you wait, Mr. D. Sharma, counsel for the petitioner. In this writ petition, the OM dated 18/1/2023 issued by the state of Assam. Department of Personnel B is under challenge. First of, according to the petitioner, his seniority has been arbitrarily downgraded in the gradation list dated 14/2/2023. Hence this writ petition. First up, Mr. T.C. Chutia, learned additional senior government advocate Assam, as well as Miss D. Bora, learned counsel appearing for the G. Bora.
For respondent number 1 and 4.
As well as Ms. G. Bora, learned standing counsel, Agriculture Department, Assam, we submit that.
I am for 2 only, my lord.
OM dated 18/1/2023 is under challenge in a batch of writ petition pending before this court, but no interim order has been passed therein. First of, the learned department counsel, however, pray for some time to seek instruction and file affidavit. In view of the above, NOM 6 weeks. Since Ms. G. Bora, learned standing counsel, Agriculture Department, Assam, has appeared and accepted notice on behalf of respondent numbers 1 and 4. 1 and 4.
I am for
And
2, my lord.
Mr. Chitia, learned additional senior government advocate Assam for respondent number 2. Nobody is for WPTBC
WPC Rahul Dhar, my lord.
as well as Mr. Ardhar, learned counsel has appeared from learned standing counsel, WPT and BC. Has appeared for respondent number 3. and no formal notice is required to be sent to the respondent numbers 1 to 4. Extra copies of the writ petition, requisitive numbers, be furnished to the learned departmental council. Petitioner takes steps for service of notice upon respondent numbers 5 to 11 by registered post with AD. Heard on the prayer of interim relief, the said prayer will be heard on the considered on the return of indictment.
Highly obliged.
This case along with WPC number 636 of the 2023 and batch of connected petitions.
May it please my lord, matter pertains to compassionate appointment. My father had died in harness while working in the irrigation department at Anganwadi on 39/2004. Thereafter, my lord, I had made my representation, my lord. It's in page 27 before the respondent number 5 to consider my case for compassionate appointment. My lord, subsequently, I had made another 2 representations on 11/2/2013 and 17/2/2023. Thereafter, my lord, my case has been forwarded.
SLC is not considered.
No, my lord.
His case was not present before DLC. His case was forwarded on 23, 18/2/23, page 37
Page 37
of
the
the
repetition.
petition.
Forwarded by whom?
The department lordship,
DLC is not yet considered.
not considered.
So you obtain instruction, Mr. So and so learned counsel for the petitioner. The grievance of the writ petitioner is that his application for appointment on compassionate ground has not been considered till today. Compassionate ground filed on, when did you file the application?
My lord, my first application I had filed on 26/8/2005.
Achha, now you have come.
Again, I have come, my lord, with a fresh application.
Fresh
My lord, on
application was
17/2/2023.
on
And
the
that has been
25th
forwarded by the executive engineer.
You can't get direction for compassionate appointment now. 2004
Yes,
father died. I'm passing this order, closing it. Yes. His application seeking appointment on compassionate ground has not been considered by the authorities. Full stop. It appears that the father of the petitioner died in harness on 39/2004, leaving behind the petitioner and his mother and other siblings. Full stop. After the death of his father, the petitioner submitted an application dated 26/8/2005 before the concerned authority, that is executive engineer, Dhemaji Zonai division of the irrigation department, seeking appointment on compassionate ground. However, no action was taken by the authorities on the said application. Thereafter, the petitioner had once again submitted an application seeking compassionate appointment on, when did you submit second one?
My lord, second one on 11/2/2013.
11/2/2013. And
Last
thereafter,
one, may I please?
again on 17/2/2013. This writ petition has been filed with a prayer to issue a direction upon the respondents to consider his application for compassionate appointment. First up. Heard Miss S. Borwal and government advocate Assam, as well as Miss
Yes,
DS
for respondent number 2, 4 and 5.
appearing for the respondent numbers 2, 4 and 5. First up. The learned department council submits that the application submitted by the petitioner cannot be considered at this distant point of time, since the very purpose of the scheme for compassionate appointment was to provide immediate relief to the family member. First up. The aforesaid submission of the respondents council could not be denied by the learned council appearing for the petitioner. First up. There can be no denial of the fact that the provision for compassionate appointment is not a matter, cannot be denial of the fact that the scheme floated by the government for compassionate appointment does not confer any right upon any individual, but the scheme is aimed at providing immediate financial assistance to the family members of the victim, of the deceased government employee, since the source of livelihood of the family stands extinguished due to the death of the employee. Full stop. In this case, the father of the petitioner had died in the year 2004, and for nearly 19 years, the petitioner has survived without any government job. Full stop. This court therefore finds force in the submission of learned departmental counsel that no direction can be issued at this point of time to consider the application submitted by the petitioner for appointment on compassionate ground. Full stop. In view of the above, his writ petition is held to be devoid of any merit and is accordingly dismissed. Yes.
Highly obliged.
Item 3 and 4.
My lord, in item number 3, I have already filed affidavit, which will call for whether it not been here. My lord. Affidavit filed in last week, my lord. Actually. My lord, petitioner, there is only one petitioner, my lord. He is actually, my lord, he below cutoff in GS1. There is general study paper 1 and general study paper 2. In general study paper 1, he's my lord, he's below cutoff, my lord. That's why he's not been selected. And he has only one grievance regarding GS1, my lord. One question number 96, my lord. He has an objection, my lord. His objection was, my lord, send it to the expert, and expert said yes, he's correct. He got mark and that. So I think he has done that way. He has no grievance at all. In GS2, he has already qualified.
It is true, Lordship. In this case, I have challenged that in GS2 paper, my mark was not properly given. But after receiving the affidavit, it is seen that
he qualified.
No, I have qualified in the GS2 paper. But I have.
So he has not qualified in GS2.
I have
GS2,
qualified in
no,
GS2, but
not getting cutoff marks. In GS1, it is only cutoff marks. GS2 is a qualifying. GS2 qualifying, he is qualified. He is qualifying score, he has 66% scored, my lord. He is getting more than 66. So that no grievance in GS2. But he has main grievance in GS2 only, my lord. But GS2 already he qualified. But even he is not getting cutoff mark, that's why he's not been called for the main, my lord.
Lordship, I want to file press petition challenging their GS1. Because Lordship, I have specially stated in my petition that I scored more than 75 marks in GS2 after calculating the negative marks also.
Let him withdraw. We'll see.
Yes, Lord.
But after affidavit is filed, how can you withdraw? After the affidavit is filed, how can you withdraw your case and then
Lordship,
rebuild another case?
I shall file my rejoinder, Lordship.
Huh?
I shall file one rejoinder and
Heard Mr. R. Sharma, Learned Counsel for the petitioner, also heard Mr. T.J. Mohanty, Learned Senior Counsel appearing for the APSC, who submits that the petitioner has qualified in the GS2 paper, but he did not secure the cutoff mark in the General Studies 1. GS1 is General Studies 1 paper, as a result of which he was not allowed to participate in the mains examination. First of all, the aforesaid stand has been brought on record by the APSC by filing affidavit dated
My lord, 12/5.
12/5/2023. However, the said affidavit is not on record. Full stop. If the stand of the APSC stands established, if the stand of the APSC is not controverted, then this court is of the opinion that there is no good ground for this court to entertain this writ petition. However, on the request of Mr. R. Sharma, Learned Counsel for the petitioner, this matter is directed to be posted again after 10 days by tagging the affidavit with the record of this case. List accordingly. What is item 4?
Item 4, my lord, there are 10 petitioners. Actually, my lord, their grievances are not same. Very different. In fact, my lord, one of the petitioner, he did not put his, my lord, rule number. Rule number, my lord. His grievance is separate. So his ground is separate, my lord, rejection. Because he is not present put, my lord. Because as per the High Court rules, my lord, it is not permissible to do, my lord, composite petition.
as per the High Court rules, if the petitioners, if their cause of actions are similar, as long as they are paying separate court fees, your lordship, then the petition is maintained.
But how can the cause of action be similar?
No, what the prayer is, your lordship. We are not challenging our selection or deselection. Our simple prayer is the copies of the OMR should be given to us and the final answer key should be published. That's all. Your lordship. That is why the cause of action is similar. Now, your lordship, what they have stated in the affidavit, perhaps it might not be on record. So I have
prepare an extra copy for your lordship.
All right, we'll have it along with the affidavit after 10 days and you file
My
a rejoinder.
Lordship,
But in all probability, we'll close it on the next day. These petitions cannot be.
perhaps I might may be able to convince your lordship because there was.
We'll see, otherwise.
No, even suppose I publish it, my lord. His rule number is not put, my lord. How can I evaluate his paper, my lord? You have to, my lord.
Heard Mr. K.P. Patel, Learned Counsel for the petitioner, also heard Mr. T.J. Mahanto, Learned Senior Standing Counsel for the APSC, who submits that the affidavit filed on behalf of the commission on 12/5/2020.
So it is in 11/5, my lord.
11/5/2023 is not on record. First of, considering the stand taken by the APSC in the matter, perusal of the affidavit will be necessary. As such, register to list this matter again after 10 days by tagging the affidavit with the record of this case. The petitioner's counsel may file rejoinder in the meantime if so possible.
May I only pray for a shorter date, your lordship, because perhaps I may be able to convince your lordship that there is a good ground for handing over the copies of the OMR sheets and publication.
But that is, what is the urgency here?
The urgency is that
You are not going to take part in this.
what the authorities have stated in the affidavit, your lordship, is that their only ground for not publishing the final answer key, as well as giving us copies of the OMR sheet, is that they want the process to.
Cancel this order. Get the affidavit. We'll take it up at 2.
Very well.
Final disposal to.
Very well. Obliged.
No. Only 4. Only side. Only 4. 3 will release. Maybe, but I will take it separately.
May I please your lordship?
Yes.
My lord, the writ petitioner who is presently serving as the chief drilling engineer in the Directorate of Geology and Mines assails the impugned notification dated 3/5/2003, whereby, my lord.
Which page? Where is it?
Yes, my lord, the notification, lordship, page 70. In the interest of public service, Sri so-and-so, IFOS, RR so-and-so, Chief Conservator of Forests, Social Forestry and MD, Assam Mineral Development Corporation Limited. Additional is also posted as Director Geology and Mining Assam as additional charge until further orders. Now, my lord, I joined in 1998. At present, I am the senior most amongst the encadred incumbents of the Directorate. There's an order from this Honorable Division Bench of this court that they should finalize the process of selection.
Where is that order?
Yes, my lord.
Page number?
Yes, my lord, I'm coming to it. Page 63 to 67, my lord. Lordship, operative part is at page 67.
Yes.
Today, we have been informed that in WPC number 4135, which was filed by the writ petitioner earlier of 2018, there are now more than one candidate in the department who are eligible for promotion to the post of director. We therefore dispose of both the writ petitions with a direction to the state government to initiate the process of selection for promotion to the post of director in the Directorate of Geology and Mining Assam in accordance with law. Thereafter, for considerable time, Lordship, no action was initiated. So I preferred a contempt. And this honorable court, my lord, kindly come to next, annexure 10, page 68. Relevant portion is at page 69. Heard Mr. So-and-so, the present application is filed under section 11, read with section 12 and 12 of the Contempt of Courts Act 1971. Inter alia alleging willful disobedience and deliberate violation of the order dated 23/2/2022 passed by a coordinate bench of this court in WPC number 4135 of 2018. Considering the directions issued by the coordinate bench of this court, right, order dated 23/2/2022, we find that there is no willful and deliberate violation of the aforesaid direction, and therefore, instead of taking cognizance of the matter, we deem it fit to
Yes,
direct
Mr.
the.
Nath, what has happened?
Yes,
within
my
2
lord.
months?
In the contempt petition present, at present pending,
So we have
Well,
filed another contempt after that when the order was not complied with within a period of 2 months.
What
Now-
order has been passed in that?
No, that is pending. They have already filed their affidavit. Now, my lord, they have come up with
No,
some,
this court will not pass any order except
the-
tagging
the-
it with the contempt case.
the last order passed into contempt case, I have given a copy, my lord. That copy I have given on 28th of April. my lord.
Because the division bench has already given you the relief. Now you can't get a better relief from the same issue from the single bench.
lordship.
So only order that can be passed is tagged with the contempt.
Yes, my
case.
lord.
In fact, my lord, at the highest level of the government, they have taken a decision to bifurcate the department and they have also taken a decision.
All right, after
Lordship.
we heard Mr. A. Sharma, learned counsel for the petitioner, I also heard Mr. D. Nath, learned senior government advocate Assam appearing for the respondents. After hearing the submissions made at the bar, this court is of the opinion that the instant writ petition deserves to be taken up for consideration along with contempt case bracket C, bracket close, number 1/2023, pending before the division bench. Registry to do the needful for listing the.
Lordship, can the order may be passed that the writ be taken up alone, because in the meantime, they have filed an affidavit and sought a leave from the court. That after 1.5 years, they have filed a review application. And the honorable division bench has observed that let the contempt come up after the review is taken up. So, my lord, since my writ is a new cause of action, let the writ be listed before the court independently, my lord.
No,
My prayer is, Lordship.
Counsel for the parties, this court is in the opinion that the division bench is in session of the central issue involved in this proceeding.
Lordship.
And therefore it will not be proper for this court to express an opinion on the grievance of the petitioner. As such, registry to teach this matter along with WPC number, contempt case number so and so. You have already gone to the division bench.
Lordship,
Division bench says
no, Lordship,
initiate process for regular promotion. Then you file contempt, then you fail. Now you have come to the single
Lordship,
bench.
because the matter has been normally listed here, I'm not against Lordship's observation that matters should be listed before the division bench. My submission is, because there is a new cause of action, let the writ petition be listed
Mr.
independent.
Sharma, the new cause of action deserves dismissal right away. This is a temporary arrangement.
Lordship,
Your only right flows from the division bench order.
Lordship,
Otherwise, you don't have any right.
Lordship,
Temporary arrangement has been made by putting someone as in charge director. You
Lordship,
can't challenge it.
Lordship.
You want me to pass that order?
But the order doesn't say in charge, Lordship.
No, it
It's
is in
What it
charge.
says?
posted as director,
No, it is in
Additional
charge.
charge.
It is-
additional
it is-
charge.
It is in charge.
Lordship.
Then, so the only order that can be passed by this court is dismissal of the writ petition. You can't challenge additional. charge.
Lordship, that
Your
is it.
prayer is that you should be considered for promotion.
My lord.
You already got the relief from DB.
Lordship.
What can the single bench now do about it?
No, my prayer is let the writ petition be listed independently before the division bench, because the
It
contempt
cannot
they
be
have
done. It
already sought time in the contempt.
Writ petition cannot be. Then the only way is to dismiss it and you have to prefer an appeal.
No, my.
Then only way is that. All right, these are technical issues. I hope
Lordship.
you understand. Yes.
Oblige me.
My lord, it is related to appointment and selection of the Gaon Pradhan, my lord. Here, my lord, kindly turn to page, my lord, 30, my lord. By agree by this, my lord, selection. It is,
So Gaon Pradhan, we have been passing consistent
yes.
orders. We'll pass the
Yes,
same
yes.
order here.
my lord, one thing I want to show, my lord.
Hmm.
Here, my lord, the recommendation, kindly turn to my lord, page 31, my lord. Top of the, my lord, right side, recommendation by non such and such dated, my lord, 4/3/2023. Then this notification that was published on 10/3/2023, and that was hang on the notice board on 25/4, my lord. So this is the, my lord, the grievance before a lordship, my lord. Because every possibility, because the name of the selected candidate is father name is my name. So my allegation is
Correct.
that
So therefore,
manipulation is there.
have you filed an appeal?
No,
No,
appeal, my lord, I have
no, no,
mentioned, my
no.
lord, why it is not appeal is filed, my lord, though there is a provision. The balance of appeal has been filed in the commissioner. These all are lying, my lord, without any progress, just they sent to the deputy commissioner for reporting. That is also file all the dump, my lord, in the RKG department without any progress. my
No,
lord.
lordship, lots of.
That is, I have,
We are passing orders to dispose of within 60 days.
Yes, lordship.
yes,
Will be contempt.
yes,
Lordship.
yes, that can be done.
Heard Mr. Mahanta P. Mahanta, Learned Counsel for the petitioner. The petitioner is agreed by the selection of respondent number 5 for appointment as Gaon Pradhan in respect of in lot number 10 of Bonmaji Moja under Borbori village in the district of Garam. By taking this court through the pleadings in the writ petition, Mr. Mahanta has argued that there are serious anomalies in the preparation of the select list, and therefore the same deserves interference by this court. Responding to the above, Mr. J.P. Goswami, learned additional senior government advocate Assam, has urged that
Respondent 2, lordship.
selection of
Three,
respondent number 2.
2, lordship.
Selection of respondent number 2.
Lordship, selection of Gaon
Respondent number
Pradhan.
5.
Selection of 5, lordship.
Respondent number 5 is.
5.
selected.
You keep quiet for a minute.
Lordship.
You're creating confusion unnecessarily. The learned government advocate Assam submits that since the selection of the respondent number 5 for appointment in the post of Gaon Pradhan is under challenge, hence the petitioner will be directed to avail the appellate remedy under Rule 162(c) of the executive instructions framed under the Land and Revenue Regulation. Mr. S. Datta, learned SC Revenue, has also submitted that similar orders have been passed by this court consistently in all such matters. In view of the above and as agreed to by learned counsel for the parties, this writ petition is being disposed of at the stage of motion hearing by permitting a week's time to the petitioner to prefer an appeal under Rule 162(c) before the respondent number 2 ventilating his grievance in the matter. If such an appeal to be filed before deputy commissioner.
No, my
No,
lord,
lordship.
commissioner, my lord, Assam division.
Uh,
No,
Sir,
middle Assam.
Before the
Middle, lordship.
uh,
It's Central Assam.
before the
Dorong.
divisional commissioner of
Central Assam
Central Assam.
Division.
He's spoken to school.
If such an appeal is filed within a week from today by enclosing a certified copy of this order, the same be considered on merit and disposed of with a reasoned order, preferably within 60 days thereafter. Until such time, the allegation made by the petitioner is verified. No order of appointment shall be issued in favor of the respondent number 5, if not already done. With the above observation, the petitioner plans disposed of.
Massive. Massive.
Matter pertains to my lord selection and appointment of Anganwadi helper. My
What is the grievance?
grievance is, my lord, the private respondent number 6, my lord. She was selected for the post, and she, my lord, did not pass the ACSLC examination. One of the main criteria, my lord, for the post, my lord, the candidate should be passed the ACSLC examination.
Heard Mr. S. A. Ahmed, learned counsel for the petitioner, peruse the statements made in the writ petition. The controversy in this writ petition pertains to selection and appointment of Anganwadi worker. Ms. S. Borwal, learned government advocate Assam, prays for some time to obtain instruction in the matter. NOM 6, since Ms. Borwal has appeared and accepted notice for all the respondents, for respondent numbers 1 to 4, no formal notice is required to be sent to the said respondents. Extra copy of the writ petition be furnished to the learned departmental counsel, requisite in numbers, so as to enable her to obtain instruction. Petitioner to take steps for service of notice upon respondent numbers 5 and 6 by registered post within a week from today. Yes.
Obliged.
May I please your lordship? This matter relates to the recruitment of the constable and the central government matter as a paramilitary forces matter. Now, whatever matter I was otherwise qualified, but when the measurement for height was taken, they reject my candidature on the ground that I am 164.5 my height. Whereas earlier two occasions I appeared interview under their sponsorship matter. My height was covered matter.
No, my lord.
My height was found 165.2 and 165 by other two centers. Last year, my height cannot be reduced within over a year, madam.
That was a different selection process, my lord. Here annexed the medical slips of earlier recruitment process.
Last 21.
So there may be error by the earlier authorities, but my lord, the provision is to appeal. They have not appealed. There is a provision for appeal under the advertisement page 20, my lord, page 29.
Mr. Biswas, why don't you consider filing an appeal? We'll ask them to consider it objectively.
My lord.
But we have filed a written complaint, my lord, they have not. Please listen, please listen. If you prefer a statutory appeal, we'll ask them to decide it in a time-bound manner. We can do it today or after 2 years, but that will be the order. The court cannot direct that your client should be appointed. That no, I am not for appointment. I have come before your lordship that let my height may be examined by any other center. So you prefer an appeal? We'll ask them to take a decision in the matter by looking into the grievance of the petitioner. They are the ones who will have to do it. But then in that event, your lordship have to fix the date, time, my lord. Yes. To dispose my appeal. How much?
Within 15 days.
Yes, we can do. Or 30 days.
30 days. 30
all right. Or Mr. S. Until then, my lord, the recruitment process, my one post may be kept vacant. No, why recruitment process? What is the stage now? Mr. Gupta,
my lord, I have to take instruction. Lord.
Physical test is going on. Or Mr. S. This was when a counsel for the petitioner. The petitioner herein had participated in the recruitment process initiated for appointment of constable oblique GB in Central Armed Police Forces for the year 2022. Full stop. According to the petitioner, he had undergone the physical standard test bracket PST bracket close and the physical efficiency test bracket PET held on 3/5/2023. However, after having qualified in the aforesaid test, the petitioner was once again subjected to physical standard test and he was disqualified in the physical standard on the second occasion on the ground that he does not meet the measurement of height. Full stop. Aggrieved by rejection of candidature of the petitioner, this writ petition he has approached this court by filing this writ petition, inter alia contending that the records would establish that the procedure adopted for rejection of petitioner's candidature was wholly arbitrary. Full stop. Mr. Biswas submits that there are materials on record to show the height of the petitioner. Therefore, the height of the petitioner, page 45, 46 and 48. The height of the petitioner could not have reduced in a period of less than a year. Mr. H.K. Gupta, learned CGC, appearing for the respondent, submits that there are elaborate official mechanism to verify the grievance claim of the petitioner and take appropriate steps for redressal of his grievance if found to be correct, and therefore the petitioner be directed to prefer a statutory appeal. Having heard the submission of learned counsel for the parties, this writ petition is being disposed of by granting a week's time to the petitioner to prefer a statutory appeal against the rejection of his candidature. If such an appeal is filed within a week from today, the same may be considered on merit and upon due verification of facts based on materials on record, a reasoned order be passed therein as expeditiously as possible, but not later than 30 days from the date of receipt of a certified copy of this order. Until such time, the aforesaid exercise is completed. One post of Constable GD under the CAPF qua the present recruitment drive shall be kept vacant. The petition stands closed. Who are the present recruitment drive?
May I please your lordship. Lordship, the petitioner before your lord, the petitioner before your lordship is a junior assistant working in the office of the Deputy Commissioner, Assam. Lordship, he has joined the department in the year 2009. And since then, your lordship, from 2012 onwards, as many as 8 times, as many as 8 times gradation lists have been prepared, where the petitioner was the senior most, was adjudged as the senior most. However, similarly, on 24/8/2021, lordship, a draft gradation list was prepared, where again the petitioner's position was placed as the senior most. However, the respondent number 4, he filed an objection where requesting for a revised gradation list, and lordship, by order dated 30/3/2003.
So you are basically assailing the promotion of respondent number 4.
Lordship,
We have to issue notice.
Lordship.
Heard, Mr.
PP Medhi, lordship.
PP Medhi and counsel for the writ petitioner. The by filing this writ petition, the promotion given to the respondent number 4 to the post of
Senior assistant.
senior assistant has been put under challenge on the ground that the authorities have not acted in accordance with law while considering the case of the eligible candidates. First of Mr. T.T.L. Leonard, additional senior government advocate Assam, appearing for the respondent number 1, prays for some time to obtain instruction in the matter. You have for 1,
1, 2, and 3.
1, 2, and 3, prays for some time to obtain instruction. NOM 6, since Mr. Chuki has accepted notice for 1, 2, and 3, no formal notice to the said respondent, extra copies requisite in numbers, petitioner to take steps for service of notice upon respondent number 4 by registered post with AD. Yes.
Deeply obliged, your lordship.
May I please this lordship?
Yes.
Lordship, this matter pertains to selection and appointment of Gaon Pradhan. Lordship, today, the leading counsel of the matter, Mr. R. Bhuya, is out of station. So Lordship may pass over the matter for.
On the prayer of petitioner's counsel, this matter stands adjourned for a week. Yes.
I love Lordship.
Mr. Das, we have fixed another matter at 2. We will
At
take up
2
this
p.m. Lordship.
because
Fine.
some affidavit has been called.
Fine.
Here affidavit probably take.
My lord, here your lordship.
All right, but we'll
Answer.
we'll take up the matter.
Yes,
together.
yes.
Lordship, all are similar matters, Lordship, escort bank matters, Lordship, condemned cases for impletement, Lordship. My case is 12 and 13, Lordship. In 12, Lordship, implement has already been allowed, Lordship. Kumar, who say implement?
Well, let us go one by one. Whose case is
Lordship.
11, item 11? Yes, give me the IF, please.
Respondent number 8, 9, and 10, because the respondent number 2 already
Give the
been
IF 11.
retired from the service. 6 and 7 already been transferred.
Take down hard Ms. J. Paul, counsel appearing for the applicant. His IA has been filed with a prayer to include the opposite party numbers
8, 9, 10.
8, 9, and 10. As respondents in the connected contempt case on the ground that these respondents are responsible for implementation of the court's order. You are appearing?
Lord, I am appearing on behalf of respondent number 3, but no copy has been served to us.
This is improvement copy.
Mr. S. Dr. Learned Senior Counsel appearing for the respondent number 3 submits that no copy of the IA has been served upon his client. In view of the above,
So first,
let this matters be listed again after 2 weeks. Copies of the IAs filed in item 11, 12, and 13 be served upon learned counsel for the respondent.
Here for the first time, so we didn't know.
All right.
No, so many dates I have appeared, my lord. Possibly the record will show.
Was there, Lordship.
All right. You give him the copy.
Sure, Lordship, sure.
Obliged.
And in my case, Lordship, item number 13, Lordship.
Respond numbers,
Respond numbers 8, 9, and 10.
same order in
Lordship.
11, 12, and 13, same order.
Lordship,
Jaypal for 11 and Mr. M. Bhagavat for 12 and 13.
Lordship, another case should be tagged along with these cases, Lordship, similar
On the
matter.
request of Mr. Bhagavati, let these matters be tagged along with.
Quantum case number 221/2023.
Yes.
Much obliged.
Right. What is item 14? Mr. Bhagavati, you are for 12, 13 and 14.
Lordship,
12, 13 and 14.
12 and 13. 12 and
Who is for 14?
Lordship, I'm appearing for
You are
Corporation
appearing
Department.
14.
Corporation
Petitioner.
Department.
for Mr.
SK Talukdar.
DK Mr. Senior Counsel.
Are you appearing for the applicant? All right, tag along with 14. That's fine.
Item 15. Me, please, Your Lordship.
Yes.
I have filed for impleading as per number 3, my lord. My lord.
Yes. Who is the respondent number 3?
Kishore Thakuria, Director, Justice and Social Welfare, Beltola. Justice and my lord.
Justice and social welfare. Is there any such
Justice and
social justice and welfare it can be?
social justice and empowerment.
So you have written justice and
Yes,
social.
my lord, that mistake.
Justice and social Beltola.
Yes,
In a hurry, filed, huh?
I will be
So
allowed
you have to correct it.
Time will be allowed.
On the request of Ms. P. Borman and I.
My lord, today, just now I correct.
No, not like this. You have to put your signature, it has
Yes,
to be
I
listed.
my hand.
On
Types of my hand.
the request of Ms. P. Borman, learned counsel for the applicant, this matter is directed to be listed again after the necessary correction is carried out in the cost title pertaining to the name of the opposite party, name and designation of the opposite party under the signature of the applicant's counsel. You correct it and signature and then listed.
I am for all this.
Ms. S. Borwa, learned counsel is present on behalf of all the respondents.
For admission.
Yes. What is
Last
this?
occasion, my lord, my counterpart, my lord, was directed to take instruction, my lord.
What is the matter about?
Matter, my lord, the petitioner with lordship was appointed as computer operator, my lord, 1/1/2009. Since then, my lord, though he is working, no salary has been paid. He is claiming salary, that is the only grievance of the petitioner, my lord. And time and again, the official respondents, my lord, they sent.
Where is the counsel? Call him, tell him to be present. Otherwise, we'll have to call the officer concerned. There is no other option. Or you want it another date?
I'll call Mr.
You call it. Yes. Yes, yes.
Item 17.
Yes, what is the instruction?
Today I have received additional copy of additional affidavit, Lordship.
You have filed.
Yes, Lordship, that is regarding some vacancy position that were in the country planning, town and country planning. That I have annexed that.
So you filed the affidavit today.
Yes, Lordship.
Is it on record?
Additional affidavit, Lordship.
Is it on record? All right, but then we have to give us some time. Today only you have filed the affidavit. Affidavit has been filed today.
Yes, Lordship. We have received it information under RTI.
So that's all right.
Yes, Lordship.
You want some time?
Yes, Lordship.
How much time?
10 days time, Lordship. Instruction also.
She is entitled to time to obtain instruction.
Instruction also. Yes, please.
Yes,
She is not
Lordship.
entitled.
No, she is entitled
All
for
right. But Ms. M. Dev, learned counsel for the petitioner will submit that an additional affidavit on behalf of her client incorporating the information called for by the order dated 22/3/2023 passed by this court has been filed only this morning. And therefore, only this morning, full stop. However, Ms. S. Borua, learned government advocate Assam submits that since a copy of the additional affidavit has been served upon her only today morning, and she be given 10 days time to obtain instruction in the matter. In view of the prayer made by the learned government advocate Assam, let this petition be listed again after 10 days as a fixed item.
Item
18.
May please your lordship. Lordship, may kindly look at the last order, my lord, order dated 22/2, my lord. My lord, the previous lawyer make submission that they are no longer in the case, and therefore the court has, this honorable court has issued notice to the petitioners, my lord. So the new set of lawyers are here, my lord. So that order, my lord, is required to be recalled. We are here, my lord. We are.
No, why should it be recalled?
My
We'll
lord.
take note that you have entered a period.
Yes, my lord. Yes.
Pursuant to withdrawal of the previous set of counsel representing the writ petitioner in this case, writ petitioners in this case, Mr. A.R. Siddharth, learned counsel associated with Miss, who are with you in this matter?
My lord.
Who are the other counsels with you?
My lord, A. Roshit and Shanti Sokravorty, my lord, maybe. No, we are here.
Mr. A.R. Siddha, learned counsel is entered appearance on behalf of the petitioner. As such, the order dated 22/2/2023 passed by this court shall be deemed to have been discharged. Full stop. Mr. Siddharth prays for, you want to argue
For the
today?
petitioners, my lord.
Sorry?
We are
You
for
want
the-
to argue today, final argument?
No, my lord, we have filed a IA. There is an order on the IA 199 of 2023. My lord, implementing response number 10. And
Mr. Siddharth submits that there is an IA being, IA number
IA 199 of 2023.
199 of 2023, which has not been listed today.
My lord, not listed. That is order has been passed, implementing the response number 10. That has that order also says that the first title is to be corrected, my lord. The correction has not been done.
Where is the IA listed today? There is no IA shown in the
Not
copy.
listed, but
Oh,
order has
no,
been
Mr. Siddharth,
already
you
passed.
try this thing somewhere else. On the request of learned counsel for the petitioner, this matter stands adjourned for 2 weeks. Mr. J.K. Goswami, learned additional government advocate Assam, Mr. S. Datta, learned SC Revenue Department Assam, and Ms. N. Bora, learned SC PNRD Assam are present on behalf of the official respondent. You want to argue on merit today?
My lord, the response number 10, my lord, is to be issued notice, my lord, and post title is to be corrected, my lord. In the IA, my lord, there is an order already.
Where is the IA? IA is not listed before
My
this.
lord listed, my lord, that is there, my lord. But order has already, IA has been disposed
Give
of.
me the order.
My lord, that we are not, IA has been disposed of, my lord, therefore not shown in this. Implementing the response number 10. 199.
Actually, you write up to order stands discharged, and thereafter you write. Mr. Siddharth submits that in terms of the order dated 31/2023 passed by this court in IA bracket C bracket 2 number 199 of 2023 arising out of this petition, the registry is yet to correct the cost title by reflecting the name of newly implemented respondent number 10. Therefore, the matter deserves rectification. Therefore, the matter deserves attention of the registry. Full stop. In view of the above, registry to so and so for the respondent. In view of the submission made by the petitioner's counsel, the registry to take note of the order dated 31/2023 and do the needful. That this petition be listed thereafter.
Item 20.
Yes, what is the matter?
My lord, the petitioner was released from service. And my lord, on the
What is this? What is that?
Lordship, this is the instruction shot by this honorable court, Lordship.
on last date, the entire file, my lord, pertaining to the appointment, my lord, was placed before the court. And this court have given me an opportunity to inspect the file. I have gone through the file, my lord, nothing adverse against me, my lord. It appointment was as
So today it has to be taken for final disposal.
Yes.
At 2.
my lord. Obliged.
Obliged.
Item 21.
May I please, Lordship, last order is 22/3/2023, my lord. And the respondent supposed to file affidavit, my lord. But they have not filed affidavit, my lord. As on today, my lord.
So where is Mr. P. Nayak? Standing Counsel PWD. You are required to file affidavit.
Item number. Yes, Lordship. We have received instruction, Lordship. Tankeshwar Bora.
So when will you file it?
Lordship, we will file, Lordship. Within 2 weeks' time, we will file, Lordship.
Heard Mr. B.K. Das, Learned Counsel. You are B.K. Das?
HP new, my lord.
HP?
New.
No. And counsel appearing for the petitioner. Also heard Mr. P. Nayak, Learned SC PWD, who submits that instructions have been received and therefore 2 weeks' time be granted for bringing the same on record in the form of an affidavit. Prayer allowed. Let this matter be listed again after 3 weeks.
Lordship.
By taking the affidavit, if any, filed by the department.
Item 23.
May I please?
Yes.
My lord, I need 1 week time to file my reply, my lord, against the affidavit in opposition.
Mr. A.M.H.R. Chaudhary submits that a copy of the counter affidavit filed by the respondent has been served upon him and therefore be granted 2 weeks time to obtain instruction and file rejoinder. Prayer allowed. Miss N. Bora, Learned SC PNRD Assam is present on behalf of the response.
Item 24.
May I please, your lordship? Item 24, your lordship, they have not filed their affidavit, your lordship. But a short issue is involved, your lordship. Regarding, she is claiming, your lordship, her seniority, your lordship. From a particular date, your lordship, on which other selected candidates were appointed in the post, your lordship. Or
So promotion with effect from the date on which
not
junior.
promotion, your lordship. Only for promotion, her claim is that, your lordship, the period of your lordship service, which she rendered under 3F, but otherwise selected under regular selection, your lordship. All the others were appointed. She was left out for some reasons, your lordship, not known to her, your lordship. Now she claims that for considering her promotion, your lordship, that period should be considered, taken into account. This
So you don't want to file a.
No, lordship, I have not yet received the instructions. The matter is before the senior standing counsel for his opinion, lordship.
Those are your problems. We are not concerned.
Then
When
lordship,
are you
may,
filing-
in the writ petition, page number 36, lordship, annexure 1.
No, Miss Bora, are you arguing on merit today?
No, lordship.
Then
It's a representation is there, lordship.
make up your mind what you want to say. The court is asking you, should this matter be taken up on merit today or not?
No, lordship.
Why not? Why not?
Lordship,
No answer.
lordship, me.
Then I'll write that the department has said that no affidavit is required to be filed.
Not, that is not I am saying, lordship.
No, either you
Lordship may
seek
give
time
me
to
two
file affidavit.
weeks time, we will file it.
Say that. You're not
Lordship.
saying that.
Lordship, sorry.
You're saying here and there. Mr. S. Bothaku, Learned Counsel for the petitioner is present. Miss A. Bora, Learned Standing Counsel, Health and Family Welfare
Yes,
Department,
lordship.
submits that the affidavit is in the process of being prepared and therefore she be given another 3 weeks time to bring the same on record.
Lordship.
Prayer allowed, register to list this case for admission hearing again after 4 weeks as a fixed item.
Obliged, lordship.
Item 25.
Lordship, in this case, lordship, I may give some time to file the affidavit on behalf of respondent number 4, lordship, the inquiry officer here in this case. Otherwise,
Why is it necessary affidavit of respondent number
Lordship.
4?
In
Mr.
my
Deori?
In my respectful submission, your lordship, we had made him a party,
All right, so he wants to file an affidavit.
lordship.
You have made him a party and you have made allegations against him. Is it not?
Yes, sir.
So how much time you want?
Lordship, 2 weeks time is necessary.
Mr. T. Deori, learned counsel appearing for the petitioner. But you are a government advocate, you are appearing for respondent number 4?
Lordship, I am on the standing council of AIDC, so on behalf of the AIDC, I am appearing here. Lordship. Not on the strength of the government advocate. Lordship.
Mr. J.K. Goswami, learned counsel, appearing for the respondents, submits that the respondent number 4 proposes to file a separate affidavit controverting the stand of the petitioner projected in the read petition, and therefore he be granted 2 weeks time to file the affidavit. Let this prayer allow, let this matter be listed again after 4 weeks, or as soon as the affidavit on behalf of the respondent number 4 is brought on record. All right,
May I pray for a fixed date, your lordship?
as a fixed item. Either 4 weeks or as soon as the affidavit is filed,
Lordship.
whichever is earlier. Yes,
2 weeks, your lordship, 4 weeks will be.
after 2 weeks, all right. See, these are unnecessary stand taken before the court, just unnecessary. You can't push a matter for hearing like this. The affidavit will be filed, you will again ask for 3 weeks time
No,
to
no,
file
your
the
lordship.
joint. All right. How can you say no? If it comes up with serious.
I will
allegation-
immediately file a rejoinder once he files
All right,
the
all right.
affidavit. Did this.
None appears to the petitioner on call. Each matter stands. Mr. Jacob Goswami, you are government advocate. here?
Lordship.
Additional senior government advocate Assam is present on behalf of the state. Since the petitioner, and you are for? And Miss, your name please?
S. Bora.
Ms. S. Bora is present on behalf of respondent number 4. Since the petitioner's counsel is absent today, this matter stands adjourned for 4 weeks. Yes.
May I please, your lordship, in this case, your lordship may kindly see the order dated 27/4/2023. Lordship, this honor. Your Honor, right?
Yes,
What is the matter about? What is the matter?
Lordship, matter pursuant to promotion from the post of Anganwadi helper to Anganwadi worker. And in the meantime, Lordship, what happened, Lordship, during the filing this writ petition, petitioner was on, she was in maternity condition. Therefore, Lordship, she applied for maternity leave and that was not granted. And by when this honorable court has directed by order dated 25/8/2022, in the interim order that was served to the Lordship, private respondent number 5. And in compliance to the direction passed by this honorable court, Lordship, the respondent has granted leave, maternity leave. Though he has granted the maternity leave, subsequently, Lordship, no salary has been released till today. And now, after Lordship, leave period is over, Lordship, I have not been permitted to join again in service, Lordship, considering that they said that I have been permitted from service, Lordship.
Please tell us one thing, help the court. Repeated requests for filing affidavit has been allowed. On the last date, it was, a last chance was given to file affidavit. On an assurance given by the learned government advocate, it has still not been done. What is the option left for the court but to direct personal appearance of the
That is
officer?
true, my lord. Today, my lord, I have my hands is time, my lord. I missed the file, my lord. I have not gone through the file, my lord. I have not taken the second copy.
The personal appearance has been
No,
thrust upon the court.
The lordship, my lord, it may be taken up, my lord, Wednesday, my lord.
Just see how many occasions time has been.
Yes,
granted.
yes, but we do admit, my lord, we do admit. Because, my lord, some problem
You
is
are
there.
making a mockery of the court procedure.
That is, my lord, today I missed the file, my lord. I cannot say anything, my lord, from the, if anything is there.
On the request of Mr.
Wednesday.
So and so for the petitioner, on the request of Mr. T.C. Chikia, learned additional senior government advocate Assam, this matter is directed to be posted again on Friday, 19th.
Obliged, my lord.
I have a fixed item.
May I please your lordship, my lord, in this matter, I am led by senior advocate Mr. UK Nair, so it may be taken up after some time, my lord. After some time.
Pass over for the time being.
Item 30.
We have challenged the gradation list because it was shifted from the district, we are initially from the headquarter cadre. Thereafter, we are shifted to the district cadre. Now, in the provisional gradation list, our names were there, but in the final gradation list, because of this notification, we have been left out of the zone of consideration. That is the case. Affidavits are there.
Lordship, we have not received any extra copies. Lordship, that is our difficulty.
Not served extra copy.
No. Serve, I think I have to inquire, but.
Give her the copies then.
Uh,
Because
I
we
have-
can't, this is 23 matter, give her copy. Heard Mr. BP Bora, Learned Counsel for the writ petitioners, also heard Miss
Z Bora, Lordship.
Z Bora, Learned Standing Counsel, Agriculture Department, Assam will submit that due to want of extra copies, instructions as called for could not be obtained by her. Miss H. S. Kempai, Learned Standing Counsel,
KAC.
KAC, you have received extra copy?
No, Lordship.
Has also made a similar submission. In view of the above, petitioners counsel to furnish the extra copies of the writ petition
Sorry.
to the Learned Departmental Council within 3 days from today, so as to enable them to obtain instruction. Let this matter be listed again after 4 weeks.
I'm sorry, Lord.
Yes.
Hello, please.
My lord, with all humility, my lord, there are the direction on us to file the affidavit by 8th.
Yes.
My lord, what happened? My chief engineer, he has signed the affidavit on 4th and he has handed over to me. We got the thing notarized even on 4th, but 5th, 6th, 7th being held, my lord. On 8th, my lord, actually, I handed over this to my clerk, my lord, and I had asked him to do it online, that e-filing. My lord, there are some negligence. I won't say negligence, my lord. I couldn't follow it up, my lord. There are some rush. And my lord, we ultimately file it on 11th. 11th only we got file. So that's why, my lord, there are the direction. If you do not file the affidavit by 8th, there will be personal appearance of the chief engineer, my lord. So my chief engineer is here, my lord. But my lord, it is not his fault, my lord. He has signed the affidavit on 4th and he has handed over the affidavit to the council on.
Have you received the affidavit?
Yes, I have received.
No, but these deadlines by the court, how is it being taken so lightly? I don't understand.
No, my lord, I never took it lightly, my lord. What happened, my lord? 4th I received. In the evening, I got it notarized even so that we can file it the next, that is on the 8th. I asked my lord will find it is on 4th. We have already got the thing notarized even in the evening.
The chief engineer is present. What is his name?
Sanjeev Sham.
Heard Mr. S.P. Sharma, Learned Counsel for the petitioner. Also heard Mr. R. Dhar, Learned SC-PWD. Mr. Sanjeev Sham, the chief engineer PWD Assam, PWD Roads, Recruitment, Assam, is personally present in terms of the order dated 21/4/2023 passed by this court. Mr. Dhar submits that in terms of the order dated 21/4/2023, all steps were taken to file the affidavit on or before 8/5/2023, and the same was also notarized, but due to a lapse on his part, the affidavit could be brought on record only on 11/5/2023. First of contending that the respondent number 5 had discharged his duties to comply with the court's order dated 21/4/2023. Mr. Dhar submits that lapses, if any, is on the part of his office. First of, however, in order to comply with the order of this court in letter and spirit, the respondent number 5 is personally present before this court today. First up, it appears that the affidavit to be filed on behalf of respondent number 5 was notarized on 6, it was notarized on 4/5/2023, which goes to show that the affidavit was ready for being filed on or before 8/5/2023. First up, therefore, taking note of the submission of the learned counsel for the department, this court is convinced that there was no lapse on the part of the respondent number 5 in complying with the order dated 21/4/2023 passed by this court. Mr. Sharma, you want to file rejoinder?
Yes, my lord.
How much time you want?
1 week time.
Mr. Sharma seeks a week's time to file rejoinder against the affidavit filed with the respondent number 5. In view of the above, this matter is directed to be posted again after 10 days as a fixed item by tagging the pleadings with the record of this case. The personal appearance of the respondent number 5 stands dispensed with for now. Dispensed with until further orders.
My lord, may I just agree, my lord, this affidavit is not there in record. May this.
I passed an order. Yes.
No, that is on record.
Yes, affidavit is on record. Yes.
But the petitioner before your lordship is aggrieved by non-consideration of her candidature for the post of Anganwadi worker, my lord, on the ground that she is not medically fit for the post, and that was based on some allegations by the local villagers, my lord. This matter came up on 10/3, and the government council stated that there has been an inquiry regarding my medical fitness, my lord, and sought for time to file the affidavit, but nothing has been forthcoming.
We have not received till today.
And you produce the records.
Sometime may be granted.
Heard Mr.
D. Kolita,
and counsel for the petitioner also heard Mr. P.C. Chutia, learned registering government advocate Assam, who prays for time till 2nd June 2023 as last chance to file affidavit. First up, prayer allowed. On the next date fixed, the learned government advocate Assam to also produce the relevant records pertaining to the medical condition of the petitioner.
Obliged.
Item 34 and 35.
Lordship, in 34 and 35, I need some time, my lord. My lord, that affidavit is already been ready. We have been sent for vetting, lordship. My lord, yet not been.
How much time you need?
Only 1 week.
Ms. R. Devi, learned counsel is present on behalf of the petitioner in item 35. None appears for the petitioner in item 34. Mr. J. Andy, learned departmental counsel submits that affidavit to be filed on behalf of the department has been sent for vetting, and the same will be brought on record within 2 weeks from today. In view of the assurance given by the learned department counsel, these matters are directed to be listed again after 4 weeks as fixed items by tagging the affidavits with the record of the case.
Obliged, sir.
No, we'll finish first all this.
My lord, he's on legs in another court, my lord.
Yes.
May I please your lordship?
May I please your lordship?
Lordship, matter pertains to the non-payment of the arrears, your lordship. Lordship, as per your lordship, as per advertisement issued by the.
Just a minute. What do you have to say?
Lordship, this matter was earlier dismissed for default, and subsequently it was restored, Lordship. Lordship, we required a entire brief. We don't have the brief, Lordship.
Even I don't have the brief also, madam. And I have requested him, madam, but he refused.
But actually, we have furnished your lordship.
No, but it was.
He has not
dismissed for
furnished to
default.
me, madam. Respond number 2, I am appealing, madam.
If it was
He's not
dismissed for
furnished.
default, then you have to give them copy.
He refused it.
Heard Mr. So-and-so.
D. Burma.
D. Burma, learned counsel for the petitioner, also heard Mr. Who is for whom?
SM Hassan.
Learned counsel for the respondent number.
Lordship, for the PhD department.
Respondent number.
I have heard too much.
Lordship, number 3, 5, 6, and 7, Lordship.
Mr. Kanikar, learned counsel for the respondent number 2, and Mr. Assam Hassan, Learned Council appearing, Learned Standing Council, PhD Department, Assam, appearing for the respond numbers
3,
3,
5 and 6, Lordship.
3, 5, and 6, who submit that his read petition was earlier dismissed for non-prosecution. But after the restoration of the read petition, no copy of the petition has been furnished to them, submitting that the earlier records are misplaced in their office. The Learned Council for the respondents have paid for a copy of the read petition. Mr. Borua to furnish copy of the read petition to Mr. Hassan and Mr. Khanekar within a week from today. Let this matter be listed again after 4 weeks.
Gotcha.
Who is appearing?
I am appearing for respondent, my lord.
None appears for the read petition on call. Mr. T.C. Patel, learned educator, senior government advocate, Assam, is present on behalf of the state. Since the petitioner's counsel is absent today, this matter stands adjourned for 4 months.
Okay.
May I please, your lordship? Lordship, I am appearing for the petitioner, my lordship, who has been given the punishment, my lordship. Major penalty, my lordship. Respondent has taken time, my lordship, in several locations for filing the reply, my lordship.
What is under challenge here?
My lordship, this is challenge under this is a major penalty of removal from the service, my lordship.
So where is the order?
My lordship, it is in page number. My lordship, page number 50, my lordship, 50.
Lord, in this matter, my lord, actually, we have filed a draft affidavit. The affidavit is there, my lord,
Sorry,
not signed by the officers, my lord.
this is the order of dismiss removal from service passed in 2017.
Yes, so all matter, my lord, the affidavit is ready, my lord. The letter I have seen, my lord, the 2018 June, dated, my lord, that was the, my lord, forwarded to the, my lord, director for signature. My lord. I will take it up, my lord, for signature, my lord. Ready, my lord, draft is ready. There was comment saying in the
Mr.
2018.
D. Hussain, my lord.
D. Hussain, learned counsel for the petitioner, submits that his client was removed from service by the order dated 16/9/2017, but no affidavit has been filed by the department till today. The learned counsel for the petitioner therefore seeks expeditious hearing and disposal of this read petition. Taking note of the facts and circumstances of the case, this Mr. T.C. Chutia, learned additional government advocate, Assam, on the other hand, prays for a week's time to file affidavit. Taking note of the submission made by learned counsel for the parties, this read petition is directed to be posted again on 30th of May 2023 as a fixed item. The department is granted time till 2005 to file affidavit if so advised. If no affidavit is filed on or before 22/5/2023, this read petition will be taken up for final disposal on the basis of materials available on record.
Highly obliged, my lordship. I'm grateful.
Obliged, my lord.
Item 39 and 40.
This is the personal appearance, my last time, my lord.
Why personal appearance?
My lord, before not complying the order dated 19/2/2022. Not 19/2, my lord. Order dated 5/2/2021. My lord,
Where is the order? Let us, which page?
contempt petition.
My lord,
Page number
page
15.
14, my lord.
Page
14, 1. And the relevant question is at page 18, my lord. Last one.
This is contempt case 437, is it?
437, my lord.
Where is the order of the court? I'm asking that.
That is, my lord, as page 14, my lord.
1-4.
1-4.
There is no order in page 1-4.
And in the contempt 437.
You see? Contempt case 438.
437, my lord, this one.
Two case 437, 430.
Is it a common order?
Common, not common order.
Not
madam.
common, my lord. Order
But,
is
but-
individual, but order is same, my lord.
Order is same, madam.
My lord, in 438, page 15, my lord, judgment.
What is the date of the order?
Date of the order is 5/2/2021.
Yes. What is the direction?
And direction is at page 1918, my lord. Page 18, paragraph 18.
So some rejection slip, is it?
Yes.
Candidature was rejected.
Rejection
Yes.
slip.
Personal appearance, who is present before the
My
court?
lord, respondent number 3, he is my lord,
My lord, he has filed an affidavit in opposition.
Regional Director, Staff Selection Commission, my lord.
And where is the order directing personal appearance?
My lord, order dated
Last occasion also on the last 12/4/2023.
12/4/2023.
Yes. So what is?
My lord, my region, my lord, kindly page number 4 of my affidavit in opposition, my lord. We had filed reply to that to the contempt petition, my lord, page number 4.
Yes.
May I read my lord last para?
Mhm.
In the similar matter, the date of birth mismatch cases of the Honorable Court has passed a judgment order dated 5/2/2021. In the matter of there were my lord 5 writ petition 2565, 2104, 2535, 2544, and 2547, wherein the Honorable Court observed that although there was a mistake in filing up of online application form, the petitioner do not gain any advantage by putting a different date of birth the online application form. As such, the Honorable Court allowed the petitioner and set aside the impugned rejection slip dated 19/2/2022 issued by CAPF. All the petitioner in the above cases were candidate of Constable GD who were rejected by CAPF at the time of DB on the ground of mismatch. My lord, after that, what happened? Kindly see, my lord, here, my lord, the petitioner is number 2, Astam Ali, my lord. Asmat Ali, my lord, number 2.
Yes.
My lord, he got 43.7900. But cutoff mark, he got the below the cutoff mark in BSF, CISF, CRPF. My last cutoff marks was also stated in that, has also stated in the affidavit also, my lord. And this is also the letter, my lord, the 2 contempt petitioner got that less than that cutoff marks, my lord, in that final selection.
No, what I'm asking is, it seems the personal appearance is directed by the division bench.
No,
Yes,
my
no,
lord, no, my lord.
My lord, the
Not division bench.
Honorable Chief Justice was sitting singly, my lord.
On that day, my Honorable Justice was sitting single. Not DB, my lord.
Acha.
And
So some letter was written that the matter has become infectious or
Yes,
something.
yes.
yes, and that's why that has been.
That letter, my lord, is at page 10, my lord, of the affidavit in opposition.
That has been rectified. That has been rectified.
Who has issued this letter 10/11/2021? Who had written this letter?
So that the
Under secretary, madam.
R. Rajakanu.
Yes, my lord. My lord, he has,
You are the,
no, he is not. He is respondent number 3 here, my lord.
He filed affidavit.
Acha. Now, what has happened to this letter?
My lord, that has been rectified, my lord.
Yes.
Yes, sir. Do you have a copy? Copy of this letter? Do you have a copy of this letter? Which? Oh, in my.
Now, this order has been passed only on 12th.
Yes, my lord.
And it does not say the earlier communication is withdrawn.
My lord, but they have rectified that. In fact, shows that the part, my lord, that first one in the first.
Yes, what is his name? You are Mr.
Mr.
Please come this side. You are Mr.
Sir, I'm Ngachan Simic.
You are presently holding which post?
Actually, I was holding the post of regional director SSC, but since 1 year I've been transferred to Directorate of Ordnance, Kolkata.
All right. Now, what has happened? Why these communications? How can you declare a court's order infructuous?
Your Honor, I tender my sincere apologies for the wrong choice of words. Actually, it was issued by one under secretary who was posted in the commission's headquarters.
This is very sad. These are so respectable organizations like yours, and you are using this. What does it mean? You are passing orders on the High Court's order.
I apologize once again. I agree with you, sir. Actually, it was inadvertently used, and this letter has been issued.
You take down, heard Mr.
R. Islam.
R. Islam, learned counsel appearing for the petitioners in both these cases. Also heard Ms. A. Gayan, learned CGC appearing for the respondents. Mr. Please give his name.
Yes, my lord.
Mr. So-and-so, who was earlier serving in the post of regional director. Regional director?
Regional director, madam.
Staff Selection Commission.
Staff Selection Commission, Northeast.
Staff Selection Commission Northeast, and presently posted as?
Presently.
As DDG, Directorate of Ordnance, Coordination and Services, Kolkata.
As DDG, you please write that
Yes,
full
Yes.
case. So posted at Kolkata is present before this, is personally present before this court pursuant to the order dated 12/4/2023 as extended by the order dated 10/5/2023. By producing a copy of the recent notification dated 12/5/2023 issued by the Under Secretary bracket P and P-I. Ms. Gayan submits that there was a mistake in the earlier order dated 11/3/2021, wherein it was observed that the order of this court has become infructuous, and therefore necessary steps for rectification of the aforesaid anomaly has already been taken. Ms. Gayan prays for 2 weeks' time to place the said facts along with the notification dated 12/5/2023 on record. Custom. Mr. So-and-so has tendered apology before this court, unconditional apology before this court for the wrong use of word expression in the notification dated 11/3/2023 and submits that such mistake will not recur 11/3/2021 and submits that the same was due to an error on the part of the part of the incumbent in the office of
Office of under,
Office of Directorate of Ordnance.
no, under one.
Under Secretary
Under secretary.
PNP-I. He assures this court that such mistakes will not be repeated in future. In view of the stand taken by Mr. So-and-so and the apology tendered by him, the court accepts the explanation furnished by the respondent number 3 and hereby dispenses with the personal appearance of Mr. So-and-so for the future dates. Ms. Gayan to file the affidavit within 2 weeks from today, whereafter the petitioner's counsel may file rejoinder. Let these matters be listed again after 2 weeks, after 4 weeks. After 4 weeks. Then we'll pass an order in this.
Yes,
But this whole today's episode was about the wrong use of the word.
No, my lord.
These responsible officers, what is the kind of expression which is being used? We don't like to call you from Calcutta, but you are compelling us to do it.
I completely understand, sir.
You can't do it. It's not done. It's not the court's orders and directions can be, you may agree, you may disagree, you file an appeal.
Yes.
You can't pass observations like this.
Yes, sir.
A time is coming when more serious action will be taken, I'm telling you. Please share this with your colleagues.
Sure, sir.
All right,
Thank you, sir.
you may leave. Yes.
Much obliged.
I'll rise for 5.
Lordship, here I need 2 weeks time. The officer concerned for whom I appeared, he is no longer there. Even then, I can take the instruction. Lordship, kindly give it 2 weeks time. Both the officers are not available.
This is the order of which year?
2022. 6/1/22.
So almost 1.5 years.
2 months.
And the direction is for?
Basically, we are concerned with 3, my lord, the subsistence allowance.
Serial number orders are there. Serial number C, paid at page 16. They are to calculate the entitlement of the petitioner and accordingly pass an order.
So what is taking so long?
But the 75% amount he has been already received, but some area possibly is not, he has not got.
As per my instruction, my lord, 25% for almost 1.5 years, my lord, he has not received. Under FR 53.
Mr. T.C. Chakravarti, learned counsel for the T. Chakravarti, learned counsel for the petitioner submits that despite the order dated 6/1/2022 passed by this court in WPC number 2907/2021, the area amount of subsistence allowance for the period of last
As per my instruction, my lord, for period of 1.5 years, my lord.
almost 1.5 years has not been paid to the petitioner till today.
Let them calculate them.
Mr. D. Nath, learned counsel, is appeared for the respondents and submits respond number
1.
One.
Here one, but 1 and 2 both are not in office now.
submits that the respond numbers 1 and 2 are not in office today, and therefore the order of this court cannot be complied with by them. However, assuring this court that appropriate steps would be taken within 4 weeks to comply with the court's order. Mr. Nath has sought posting of this matter again after 4 weeks. In view of the submission made by Mr. D. Nath, this matter is directed to be listed again after 4 weeks.
Lordship.
Obliged.
Item 42.
So this matter pertains to non-payment of arrears salary as well as payment of non-practicing allowance to the petitioner, my lords. In the meantime, my lords, the arrears salary has been paid to the petitioner, and now the question of non-practicing allowance was there, my lords. But in the case of the petitioner, he had never moved an application. My lords, on the last date, and direction was given to move an appropriate application in front of the principal to consider the case of the petitioner for the non-practicing allowance. My lords, the application has been moved and the documents has been considered and forwarded to the government, my lords. So we'll need some time to process the claim of the petitioner.
I have submitted an application.
When did you submit it?
within 7 days.
No, no, what is the date of your
Date
application?
of 16/04/2020. I have got a copy, Lordship. Yes.
Yes.
So it was submitted to the principal, my lords. Now principal has forwarded to the government, my lords. So some time will be required to consider the case of the petitioner, my lords. Well, I will,
Sometime means how much?
lordship, that we cannot give a definite, lordship, 4 weeks time, in 4 weeks time, we can consider, the documents are moving, my lords. I have the principal has already forwarded to the DME, my lords. I can.
These things will require a little time.
Lordship,
Lordship, may I make a humble submission, Lordship? If I am found to be wrong, Lordship, I beg to be excused. Lordship, page number 12 of my contempt petition. Order from this honorable court, Lordship, on 14 September 2018, Lordship. 2018, 14 September, first para, Lordship. Page number 12, Lordship, of the contempt petition.
Yes,
Lordship, first para.
yes.
That the regularization of the services, Lordship. Not only by giving retrospective effect to such regularization, but all consequential benefits have also been given to the petitioner. So an undertaking was given by the respondent, Lordship, that all consequential benefits accruing from the regularization. I was not getting anything because of non-regularization, and regularization was done after 20 years, Lordship. 20 years later, then when it should have been done. And the consequent benefits of the regularization are that I get the annual increments, that I get the benefits of the new pay commission, that is the 6th pay commission at that time. And I get the non-practicing allowance, and other allowances also. And Lordship, the third thing, Lordship, because they have undertaken to pay me all the consequential benefits, Lordship. Now I refer to an order of the Honorable Supreme Court, Lordship, and which is there in the page number 12 of the II, Lordship. Page number 14 of the II, Lordship.
The order which my friend is relying upon, that is not the order that has been willfully
All right,
violated.
let him,
Lordship,
we'll give him another 2 minutes.
Lordship, yes.
I understand what he's trying to say,
Lordship.
but let him have his satisfaction.
Lordship, that is page number 14. And it says that there can be no gains. That is the big para, Lordship. The para 14, Lordship. That there can be no gainsaying the fact that the government which has delayed the payment of salaries and pension should be directed to pay interest. Sir, Lordship, if the consequential benefits includes the interest payment also, and Lordship, the Honorable Supreme Court has also averred that this is not a punishment on the respondent, Lordship. This is just a compensation, Lordship, because what I was entitled to get 27 years back does not have the same value now after 27 years. So this is a compensation. This is not a punishment given today.
So therefore, what is that you want to say?
I want to say that the payment of the interest as per the order of the Supreme Court is a part of the consequential benefits, Lordship.
No, but has the learned single judge given that relief?
Lordship, learned single judge has directed to raise that issue, my lords, in front of the government, and the government to consider the statement of the petitioner, my lords. There was no direction to give interest, my lords, because that is in page number 17 of the contempt.
Where is the order of the single judge?
Page number 17, Lordship, is the operative part, my lord.
Page number 17.
Lordship, of the contempt petition, my lord. Point 2, Lordship will specifically mention the petitioner has submitted that he has not been receiving his area salary as well as non-practicing allowance. In this regard, the learned counsel for the health department has submitted that steps has already been initiated to grant the benefits of the petitioner in person. However, the petitioner person would be free to raise his grievance for the same by his representation as indicated herein before, my lords.
And the next paragraph, it is needed to say petitioner has any further grievance, then he can
free to agitate such.
So you make a representation before the government.
I have already made a representation, Lordship. I have made the representation. In the representation, before coming to the honorable court with the contempt petition, I have raised all these issues. That, my arrear pay plus the non-practicing allowance plus the interest.
Here
And I have
the
given
difficulty is, Lordship, the representation that has been made, my lords, the post where he has made the application, my lords, those officers are not there anymore. That post is in itself is not there, my lords. So if the learned friend can file a fresh application, my lords.
At the moment, he is not your learned friend. He wants his non-practicing
Yes,
allowance.
that has been considered, Lordship. I can produce the document. I'll forward it to him also, that the steps taken.
Mr. Dr. Laskar, you are. is
Yes,
it?
Lordship.
You see, these issues have got certain legal impediments. The learned judge has not granted you the relief of interest. This matter cannot be dealt with in a contempt case. Contempt case, it is only on a limited sphere of compliance of the court's order. That is how the law operates. You can get some clarification from any of the learned counsel sitting there. Here we will only be concerned with what is been given to you by the court. Arrear salary and non-practicing allowance. Arrear salary you have already received. Non-practicing allowance, now you have filed an application. They have not rejected it.
No, Lordship.
They are only asking for some time to process it. If there is anything else and the government rejects your application, you have to file a fresh writ petition. That is the only way out. Whether you like it or not, that is how law operates. That is the mandate of law. And I don't wish to go very deep into this. So just so that you don't feel that the court is not appreciating your grievance, I am saying all these things. Otherwise, we are not required to give any explanation. But if the government rejects your application for interest, then your remedy will lie in filing a fresh writ petition for that. Beyond that, I cannot say anything. So we'll give him
4 weeks time, Lordship. In
2
that
weeks time. Let us see what they do to your application.
Lordship, 3 weeks.
Dr. Basanta Laskar is personally present in this case. Mr. H. Earlier, Learned Counsel appearing with the respondent submits that the application for the payment of non-practicing allowance was submitted by the petitioner only on 16/4/2023 before the principal of the medical college.
Yes, Lordship.
Got him.
Assam Medical College.
Which has now been forwarded to the government. The application is being examined in the light of the order passed by this court. As such, 2 weeks time has been sought for by Mr. Chalia.
3 weeks, Lordship.
3 weeks time has been paid. You
Lordship.
take 4 weeks time.
4 weeks, Lordship.
But after that, I will not give you.
No,
any time.
Lordship, we'll
4
show you-
weeks time.
we'll come to a
has
logical
been
end.
sought by Mr. Chalia so as to come up with a concrete stand in the matter.
Yes.
Considering the facts and circumstances of the case, as well as the fact that the application seeking payment of non-practicing allowance has been made by the petitioner only on 16/4/2023 during the pendency of this petition. I am inclined to grant 4 weeks time to the respondents' counsel to obtain instruction. Let this matter be listed again as a fixed item on 12th of June, 2023. It is made clear that prayer for adjournment on the ground that the matter is under process may not be entertained on the next
Lordship.
date fixed.
My lord, the petitioner before the learned single judge, my lord, has prayed for, my lord, made 2 prayers, my lord, for the grant of arrear salaries and my lord for regularization of the gap. My lord, because the petitioner was in between terminated from service due to some criminal allegation against him. Later on, he was acquitted by the criminal court. So he was reinstated back in service. So my lord, the writ petition was preferred praying these 2 things, my lord, for grant of arrear salaries and for regularization of the gap period, my lord. So far as the my lord, gap period is concerned, my lord, the honorable single judge rejected that prayer on, and the second prayer of grant of arrear salaries, my lord, the court has directed to pass a reasoned order. Now what has happened, my lord, after the passing of this order, the authorities have stopped my pension. During the pendency of the writ petition, my lord, an interim order was passed directing to grant provisional pension. Provisional pension was accordingly granted. That interim order, my lord, merged with the final order, and there was no discussion on the fact of non-payment or non-entitlement of the grant of provisional pension or the pensionary benefits to the petitioner. Now, my lord, what happened after the passing of this
So you are
order?
not getting any pension now.
I was getting, my lord, after the passing of this order, my lord, quoting that order, the authorities have stopped my pension and ordered for recovery. On a misinterpretation of the order, my lord, complete misinterpretation of the order.
File a review of that order. Or a writ petition, either of the two. Contempt, we cannot go so deep into these things. The contempt case may be pending. The court finds that there was any deliberate attempt, then it is a different thing. But all these things cannot be handled in a contempt case. Choice is up to you.
My lord, the petitioner has claimed certain relief.
You argue, I'll pass an order, but
My lord.
the fact is this.
My lord.
Your problems cannot be sorted out only in a contempt case. That is the order I'll pass. You can argue. You have to either file a writ petition and express your grievance. Your grievance cannot be looked into in a contempt case. The court will only look into.
The only difficulty is, my lord, the petitioner, because of their, my lord, wrong
But you will
action,
still
my lord,
not file a
I
writ
have to file writ petitions after writ petitions.
Correct.
My lord,
You want time to file, to seek instruction?
No, Lordship, I have filed a affidavit in opposition, Lordship.
let's say.
I am for responsible to Lordship. Even Lordship, I have been misimplicated, Lordship. Misjoined. I am a misjoined in this case, Lordship.
Why his pension has been stopped?
He is not entitled for pension, Lordship. He is not entitled for pension, Lordship.
There was no such
The
right.
provisional pension was given in terms of the interim order. After Lordship kindly see the order of this honorable court, what order has passed, Lord. Thereafter, we have stopped the pension, Lord, because he is not entitled.
The order, I'll close the proceeding.
Had they passed an independent order, my lord, I would have preferred an
Gupta,
petition.
I told you,
My
your remedy lies in filing a writ petition.
Lordship.
You have taken a stand which
My lord.
I don't understand why. I'll close this matter then. You have to file a separate petition. Where is the order?
Page 29, Lordship. Contempt petition.
Page
29 of contempt petition, Lordship. The order passed by the learned single judge.
yes, where is the operative part?
Page 33, my lord, paragraph 10 and 11. Paragraph 10, 11 and 12, my lord.
Had Mr. H. Gupta.
And
Learned
paragraph
Counsel
12, my
for-
lord, will see paragraph 12 also. As the writ petitioner has retired from service and is drawing provisional pension, if the order of entitlement of time scale goes in his favor, the provisional pension will also be modified. So there is a direction, there is no direction for stoppage of pension.
There is no direction to give you pension as well. It is just because of your obstinate stand today that your client is going to lose. A smart lawyer would have immediately said, give me time to file a writ petition. But I am not going to give you time now to file a writ petition. All right.
My lord, we
Mr.
keep
H.
it,
Gupta, learned counsel for the petitioner, also heard Mr. S.S. Roy, learned counsel appearing for the
Respondent number 1.
respondent number 1 and Mr. P.P. Dutta for respondent number 2, alleging willful disobedience of the order dated 17/6/2022 passed by this court in WPC number 2258 of 2020. This contempt case has been filed, inter alia alleging that after the writ petition was disposed of, not to speak of finalizing the provisional pension of the petitioner as per his entitlement in the time scale. Even the provisional pension has been stopped. Was full stop. Not only that, the respondents have issued an order for recovery of the amount of provisional pension already paid to the petitioner. Full stop. Mr. Gupta submits that these are issues which will have to be dealt with in the present contempt case in view of the observations made by the learned single judge in paragraphs 10, 12, 10, 11, and 12. Mr. Roy, on the other hand, submits that the provisional pension was being paid to the petitioner as per an interim order passed by this court. However, as per the service rules, no pension is payable to the petitioner. Since the learned counsel for the petitioner has relied upon observations made in paragraphs 10, 11, 12 of the order dated 17/6/2022, the said observations are reproduced here below for ready reference. Page 33, double tick. After going through the observations made by the learned single judge, I do not find any specific direction passed therein, deciding on the basis of adjudication on the entitlement of the petitioner to receive pension, and that too at a particular time scale. Rather, the matter has been left open to be decided by the appropriate authorities on verification of the record. If the respondents have taken a categorical stand in their affidavit that the petitioner is not entitled to pension and therefore the amount is liable to be recovered, the aforesaid, the same in the opinion of this court gives rise to a fresh cause of action which cannot be adjudicated in a contempt case. Therefore, by granting liberty to the petitioner to seek redressal of his grievance in an appropriate proceeding, this contempt case stands closed.
Oblige, your lord. What will give you liberty to file this?
If you would have filed a writ petition, we would have taken both together. I don't know what is the training from which.
My lord, the PPO order has been issued in this case. After the issuance of the PPO order, now they are.
Fine, is you want the order to be stayed in a contempt case?
I will file a fresh.
You'll file it now, but without the contempt. If the contempt was pending, it would have been so advantageous to your client. It is only because of you, the court could not keep it open.
Oblige.
These are again contempt petitions, my lord, where we have alleged that the order directing for my review medical examinations were not complied with in the spirit in which the orders, honorable court had passed the orders. But today I am told that there was some.
Review medical board was constituted on 18th of October 2022, and he was examined, and due to overweight and hypertension, he was again rejected.
I just one thing. The petitioner, when he got the order, there was an order to do a medical examination. He was subjected to the medical examination. He was found fit. Second time they did it again to hold me unfit. Now, my lord, if the spirit of the order had granted them the liberty to do it in a particular manner, and they have deliberately did it a number of times to ultimately frustrate that order. In my humble submission, if he comes up with an affidavit, I will have that order with my hand in which they have done it. I can either challenge that order, or I can try to show that it was a deliberate attempt to frustrate the order.
I'll file an affidavit.
Counsel for the petitioner also have Mr. KK Parasar.
For respondent number 2, my lord.
Appearing for the respondent number 2. KK Parasar, learned counsel appearing for the respondent number 2, who submits that even the review medical board had found the petitioner medically unfit, but the said facts along with the supporting documents will be brought on record by filing an affidavit within 4 weeks. In view of the submission made by Mr. Parasi, this matter stands adjourned for 4 weeks, so as to enable him to file affidavit.
Similar would be this.
45 also same, my lord. 45 next,
Same
same one.
Same order, list along with 44.
I'm obliged.
Obliged, my lord.
May take a Service is complete also. No response has been filed. We should
Lordship,
come up
we have
with
received-
admission.
Lordship, we have received instructions. We'd like to file affidavit.
Mr. J. Kolipal, I counsel for the petitioner submits that this matter is ready as regards service and therefore can be listed for admission. Mr. Assam Hassan, learned counsel appearing for the
Respondent number, Forest Department, respondent number 1 to 4, Lordship.
respondent number 1 to 4 submits that he has received instruction and be granted how much time?
3 weeks, Lordship.
3 weeks time to file it. In view of the above, register to verify as to whether any counsel has appeared for the remaining respondents and list the matter thereafter. And list the matter after 4 weeks by taking affidavit, if any, filed by the department. With the record of the case.
May I please, Lordship? Lordship, this contempt is the first time Lordship is told. I therefore.
Notice has not yet gone.
Not issued.
Where is the order?
Lordship, page Lordship 10, Lordship. And page 9, sorry, Lordship, annexure 1, Lordship. Lordship, operative parts, Lordship, at page 11, Lordship. Paragraph 6, in view of the above submission made by the learned counsel for the parties, this petition is disposed of in a line of the order dated 27 past in the repetition of the repetition answer. If confirmation of the petitioner's service is a hurdle, then the state shall take appropriate action toward the expected confirmation of the petitioner's service. The entire exercise should be carried within 3 months by Lordship. Thereafter, Lordship, page 19, Lordship, the settlement officer, Lordship, submitted all the documents, Lordship. Settlement officer, Lordship, submitted all the relevant documents before the Lordship Directorate, Lordship. Last page, Lordship, I see. Lordship, but till to date, Lordship, nothing has been done, Lordship.
Mr. B. Malakar, learned counsel for the petitioner, alleging willful disobedience of the order dated 26/9/2022, passed in WPC number 4932/2020. This contempt case has been filed. I have perused the statements made in the petition. Issue notice returnable in 6 weeks. Petitioner to take steps to service of notice upon the sole respondent by register post within a week from today. Good.
May I please, Your Lordship? My lord, IA is for implement of opposite party as respondent number 2, my lord.
Who is the opposite party?
My lord. Principal Secretary Finance, my lord.
Why you already have commissioner? Where is the order? Let us see.
Order dated 20 February 2023.
And there is an order of this court also, my lord, to impede him. Page 9, para 6, my lord.
So proposal has been sent to the finance department.
Yes, Your Lordship. The proposal has been sent from the Revenue Department to the Finance Department. That's why, in the main case, Your Lordship, Finance Department was a party. But the finance was not made a party in the contempt case.
Heard Mr. So-and-so learned counsel for the AHMR Chaudhary, learned counsel for the applicant. His IA has been filed with a prayer to impede the opposite party as respondent number 2 in the connected contempt case. Mr. Chaudhary submits that the proposal has been sent to the finance department as per the order of this court, but no action has been taken in the matter. by the Principal Secretary of the Finance Department. Hence this IA. Ms. Bordole, P. Bordole, learned
N
N.
Bordele.
Bordole,
N Bordele.
N.
N Bordele.
N. Bordole, learned counsel is present on behalf of the respondent number 1.
1 and 2. Or sole respondent, I'm sorry.
On behalf of the sole respondent, in view of the prayer made by the applicant, and the grounds on which implement is sought, this same stands allowed. The opposite party is hereby implemented as respondent number 2 in the contempt case. Register to make necessary endorsement in the cost title and list the matter thereafter for necessary orders. IA stands disposed of.
Obliged.
I'm obliged to Lordship.
46.
May I please, Your Honor?
May I present? In this, case, Lordship, they have not served copy to ask Lordship. Review petition not served.
We'll solve the copy.
Let it be. Lordship, after. In this kind of matter, similar matter is also filed, the repetition is filed. That is
Yes.
WPC number 228723. Lordship.
What is this about? What is this?
This is regarding appointment of Gaura, my lord.
What is the review you are seeking?
My lord, lordship will find the order passed by this honorable court at page 66. And operative part, my lord, page 67. And lordship may see, my lord, page 68, second para, my lord. Sorry, my lord, third para. Page 68, third para. That was the.
So why review?
Yes. Now, my lord, after this order, my lord, we have come across the notification. Lordship will find at page 70. Yes, 70. My lord.
25 years.
Yes.
After that, there is another one, 30 years.
35, my lord,
Even the
25 years.
notification will close the matter tomorrow.
Yes, 25 years in place of 35 years.
Again, it has been brought back. Now it is 30 years.
Now 30 years.
This is how it is going round and down. On Wednesday, we'll close the matter. Can you give him the notification or Friday?
On Friday.
Mr. M. Mondal, Learned Counsel for the Review Petitioner is present. Mr. S. Dr. Learned SC Revenue Department submits that no copy of the review petition has been served upon him. In view of the above, copy of the review petition was served upon Mr. Dr. and Mr. J.K. Goswami, Learned Government Advocate Assam, appearing for the official respondent. Registered to list this matter again on Friday, that is 19/5/2023.
Along with WPC number 2287.
No, why along? We'll close it. By reflecting the name of Learned Counsel for the parties in the call. Please give him a copy of the latest notification.
Lordship.
And he will withdraw the matter on 19.
Lordship.
Obliged.
In this case, Lordship, on behalf of BTC, we have filed an IA. There is an order which Lordship will find in the IA. If Lordship is pleased to take the IA 888/2023 at page 21. There is a central selection board, Lordship, in terms of the provisions of clause 5.4 of the memorandum of settlement entered between Government of Assam, Government of India, and the Borough people at that point of time, BLT, Lordship, of 2003. In this order, according to the provisions of this MOS, Lordship, the time to time the committee is constituted, a central selection committee for selection of various grade 3, grade 4 post, Lordship. In 2018, there was a committee constituted and which was cancelled. And that is the impugn order in the writ petition. That was cancelled on 26/2020 at page 66 of the writ petition. Challenging this, the writ petitioners came before this honorable court, and this honorable court on 24/8/2020 was pleased to issue an order. Notice was issued, no stay was granted. However, there is a clause at page 22, second paragraph. After hearing the learned counsels, this court is of the opinion that the interest of justice would be made if a direction is given that in the event that the elected bodies of the respondent intended to constitute a fresh selection board, the same would be done only by taking leave of this court. So this IA is basically to seeking leave. Otherwise, also this committee, which was considered in 2018, is going to expire in 1 month's time. So this is my case because till now, after constitution of the new BTC Council, for 2.5 years, there is no development regarding recruitment of the grade 3, grade 4 post because of this embargo.
May it please, Your Lordship. Lordship, the writ petition was filed in the year 2020, my lord. And the core question, my lord, was whether the cancellation of the board in the midterm was legal, my lord. In fact, numerous legal points were raised in the writ petition, like whether doctrine of pleasure would apply or not. My lord, in my humble submission,
So
my
when,
lord,
what is the term? When does the term of the previous board end?
it would expire in the month of June this year, my lord, perhaps. But if my lords holds, my lord, that the termination was illegal. So what I am suggesting, my lord, that the respondents have till date not filed any affidavit in opposition to my writ petition. Although they have filed a interlocutory application, there is not a single paragraph explaining their stand, my lord. Now, if the respondents wish to argue the matter without an affidavit, lordship would fix it next week, my lord. I'm ready to argue the matter on merits, my lord. Because this is my affidavit in opposition file, my lord. Since
No, you may be ready, but we may not be ready to hear.
my lord would fix it that any date convenient.
What is your stand on the IA?
My lord, the IA does not raise any points. It just says that they want leave. There's no explanation why they want leave, no explanation on why the board was terminated in the midterm. There's nothing in there, my lord. That's why I didn't file a reply, my lord. Lordship may peruse the IA, my lord. There's nothing.
No, the learned judge is given the liberty. They
Yes,
are not
yes.
entitled to.
Well, if that liberty is granted with all due respect, my lord, that would make my, as on date, that would make my writ petition infactual.
That means you are aggrieved by this order.
My lord.
That means you are aggrieved by the order of the learned single judge.
My lord, that
24/8.
leave is perhaps the leave was granted. My lord, there's another, my lord, peruse the order. There's also an order
Mr.
for
Mohanto,
early
you
disposal.
you are a counsel. Be
I
logical and legalistic in your approach.
My lord.
Or after hearing your grievance, the learned judge does not pass any interim order,
My lord.
but has merely said that if a fresh central selection board is to be constituted, the same can be done only by obtaining the leave
Yes,
of the court.
that leave would be,
Just a minute.
I'm so sorry, my lord.
So they have now approached the court seeking leave.
My lord.
You please respond to that, as simple as that.
Yes.
You are going on final hearing, affidavit, this, that.
My lord,
We are not going to go into all these things.
my lord, the order, my lord, my learned senior friend has referred, my lord.
If
Now,
the leave is not granted, how do you stand to gain?
After the leave, my lord, if I may kindly point
If
out, my
the
lord,
leave is not granted by this court,
my lord.
how does your client stand to gain?
My lord, if the leave is not granted, my lord, in my humble understanding, my lord, that if the court grants a favor, grants an order in our favor, holding that the termination was illegal, perhaps I have judgments to the effect, my lord, which says, my lord, the petitioners have to be restored back to their original position, my lord, because they were terminated in the midterm. So the term which was left, my lord, sans the termination, would be available to them. In my humble understanding, I may be wrong, my lord. That's why, my lord, I was suggesting, my lord, that the matter may be taken up and the last paragraph, your lordship kindly peruses of the order. It says pleadings may be exchanged before the next date so that an early date of hearing can be fixed in this matter. If the pleadings are exchanged prior
Mr.
to
Mohanto, we are not hearing this matter this year. You argue only on the IA. Don't try to push it to the final hearing. These things we don't appreciate. The IA has come, you ask, you take your stand on the IA. You can't say that because he has filed the IA, you hear the matter fine. That order you should have got at the time of your moving the case. Today we are only concerned about the IA. We'll either allow it or dismiss it.
my humble submission, my lords, to allow the prayer made in the IA, the issues has to be decided, my lords. Because, my lord, if I concede that leave may be granted, then my
But you don't want to file any objection.
matter becomes, well, I'll file an objection. Lordship, give me just.
They had already taken time, 3 weeks time already taken. And we have given the grounds in the leave application, paragraph 4 and 5. why I want to constitute it, Lordship. Huge number of vacancies are lying. They have already obtained time.
So the constitution of the new board will be subject to outcome of the.
Well, I was of the opinion, my lord, since there was nothing on merits, my lord, regarding in the IA, my lord. I thought the reply was not necessary.
No,
If your lordship desired, lordship would just give me one.
Paragraph 4 and 5, Lordship. Very
Next week,
categorically. we have
lordship
to.
would fix it, my
We'll
lord.
take up the matter on Friday, whatever you
Lordship,
want to do.
Friday I am not.
Monday,
uh,
22nd.
22nd I am available. Lordship, already paragraph 4 and 5 we have very categorically said, and they have already obtained substantial. When we have filed it, Lordship, long time back.
Mr. Mohan.
It was filed in the month of March.
Monday.
In the month of March we have filed.
Matters.
Monday.
You are opposing us.
Monday.
Application filed by a statutory government. You don't even care to file an objection, and you are saying here we are definitely not going to hear the writ petition.
I'll file.
Question doesn't arise.
I'll file an objection, my lord. Lordship would give me
We are
liberty.
taking up the matter
Monday.
22nd as a
Lordship.
fixed item.
I may be allowed.
You do whatever you want.
I'm obliged, my lord. Obliged.
I heard Mr. B. Saikel. You are appearing as AG here
As a senior standing counsel BTC.
and Senior Standing Counsel BTC as stated by Mr. R.S. Mushari. R.K. Mushari and a counsel for the applicant. This IA has been filed with a prayer to grant necessary leave as per paragraph, as per observations made in order dated 24/8/2020 passed by the learned single judge in WPC number 3267 of the 2020. Mr. Mohanta prays for 3 days time to file an objection. Prayer allowed. If the objection is brought on record on or before 18th of May 2023, the same will be tagged with the record of this case. List this case again on 22/5/2023 as fixed item.
Hello.
Deeply obliged.
I stand for, no, I'm responding. I'm for the respondent number 5, my lord, put here by name. So I filed an IA that I may be struck off because when I was the ex officio director, which is respondent number 4, I had filed an affidavit in opposition in that capacity in WPC 1281 of 2020 on 13th May 2020. And I filed an affidavit in opposition in IA number 1285 of 2020 on 15th September in 2020. And accordingly, my lord, this is the third time that the petitioners have come before my lordship on the same grievance. They are the unsuccessful candidates of a selected post of master weaver under the handloom department. Now, question is that I'm no longer the director, my lord. I'm posted to some other department. They put me by name. And the same issues which were raised in the earlier WPC and the earlier IA is now being agitated before my lordships in the present WPC. It was dismissed earlier on withdrawal, dismissed on withdrawal. Earlier on that withdrawal, my lord, they came in different names. The 89 out of the 89 candidates, only 6 were selected. Now unsuccessful candidates have come before my lordship.
Challenging the selection.
And who is appearing for the writ petitioner?
We have no idea, my lord. It's been unrepresented for many times.
Also dismissed for non-prosecution. This was dismissed for non-prosecution by the same.
So this IA has been listed for the first time.
First time, my lord. We filed it, both of us have filed separate IAs.
I have also filed an IA.
And what is your IA number?
My IA is not listed, 1255. I filed for dismissal of the writ petition lordship.
All right. So, Mr. Chaudhary, what we'll do is we'll fix it on next date
My lord,
because the petitioner is absent.
my lord,
And if he remains absent on the next date, then
my lord,
we'll pass him on.
absolutely.
So we must give him one opportunity.
My lord.
Heard Mr. P.N. Chaudhary, learned counsel appearing for the applicant in IAC number 1036 of the 2023, which has been filed by the respondent number 4 in the writ petition.
Respondent 5.
Respondent number 5 in the writ petition for striking off her name from the array of parties on the ground that there is no bona fide basis for the writ petitioners to implead the respondent number 5 in this case. First up, the petitioner's counsel, the counsel for the writ petitioner is however absent. Under the circumstances, this court is inclined to adjourn this matter till 31st May suits you?
31st, my lord, if it could be slightly before that, my lord.
Yes, you suggest a date.
My lord. If it could be on the 30th. It would suit, can we?
30th of May 2023, so as to give one opportunity to the writ petitioners to appear and contest the matter.
Deeply obliged.
I am appearing for respondent number 10, 11 and 12.
Mr. So-and-so appears for responding. Your name, please?
10, 11 and 12.
And
Lordship, I am for 13 to 18. I have also been listed, Lordship.
no,
13
you-
to 18.
that you make a mention. That
Lordship,
I hear.
Lordship.
Mr. So-and-so for respond numbers 13. M. Hussain. MK Hussain for respond numbers
13 to 18. Select
13 to 18. And Mr.
H. Khandakar,
A.H. Khandakar for respond
10, 11 and 12.
10, 11, 12 in the writ petition are present. We'll take up the matter on 30th.
30th, obliged.
Lordship, we have filed an IA for striking out petition number 1. Actually, it was inadvertently added. He was for a different revenue values. So with a liberty to file it afresh because it is for a different revenue village, Lordship. Petition number 1, 2, 3, 4 are for this revenue village.
Is it permissible?
Well, he wants to get his name struck up from the petition number 1 because he does not belong to the area where the Gaon Board is selected.
Correct. I am asking, is it permissible under the law?
Well, I think striking down is permissible if others petitioners that they are.
Yeah, Lordship, the court can add or strike off parties on its own, Lordship. Whether IA is maintainable or not, that is court under
You want
226.
whose name to be struck off?
Abdul Kadir, Lordship, petition number 1. At page 5, para 2, I have.
See, Mr. Bora, I would have allowed your petition, but I will not do it today because please read the CPC. The only ground when plaintiff striking off name of defendant is a completely different thing.
Oh, yeah.
Adding a party is another thing.
Yes.
If you want to strike off a plaintiff, then all plaintiffs will have to make a joint prayer. Here,
Yes,
you want the striking of name of petitioner number 1. He has filed an affidavit. He doesn't even say that he is competent to swear this affidavit on behalf of the other petitioners. These are technicalities in law.
Okay, Lordship has the power to withdraw, strike, Lordship, if Lordship pleases.
Then you argue the matter. Legal matters are to be dealt with.
No, Lordship, then I have to file afresh.
You withdraw and file
afresh.
Legal matters will have to be dealt legally. You cannot suddenly one plaintiff, one petitioner cannot come and say that I want to withdraw. That is not permissible.
Yes, yes.
Court has the power or not, forget that. That you don't have to tell us. Why should we exercise that power?
Yes, Lordship will file it afresh with proper affidavit from the other.
Let the other petitioners, there has to be a statement that other petitioners do not have any objection. And the affidavit must support these statements on being authorized by the other petitioners. Then we'll consider, not otherwise.
Okay.
Yes, sir.
Mr. Sharma, what to do? People are forgetting the basics.
No, my lord. I thought that because I have already withdrawn stock of number of cases, only teaser cases. But the affidavit was on behalf of all the petitioners.
Lordship,
Recently,
I don't know. I
got
just learned
16 petitioners stuck up in court number 4 manner. Because the affidavit was on behalf of everybody.
He has not filed affidavit.
And in fact, we are
affidavit only individual capacity of.
Not only that, with the IA, all the petitioner had signed the Okla. Yes.
Then, yes, if
Yes.
everybody comes,
Yes.
then it's fine.
That is the idea.
Yes, Lordship, I'll do that.
Yes.
Let him withdraw and file afresh.
Yes. Yes. Let him.
All right, Mr. B.P. Moral and counsel for the applicant seeks leave of this court to withdraw this IA with liberty to file afresh after rectifying the defects. Mr. R.P. Shaman and a senior counsel appearing for the respondent number.
4, my lord.
Respondent OP number 4
Private respondent.
is present and does not have any objection if the prayer is allowed. In view of the above, Mr. S. Dutta, learned SC Revenue is present on behalf of the department.
Yes.
SC Revenue and Ms. S. Borwell and Government Advocate Assam are present on behalf of the official respondent. In view of his IS is disposed of on withdrawal with liberty as paid for. You read that provision of CPC, I will not tell you.
Order 1, Rule 10(2).
Go and first read it. Withdrawal. It is not about adding.
Yes.
Why are you relying on a provision of adding when you want to withdraw? You want a deletion.
Okay.
You want, one of the petitioner wants to withdraw from this proceeding. It is not even an application for withdrawal of the writ petition. Check up the provision. I am going to ask you next day.
Yes.
Well, there is another IA.
Another IA for vacating. I will file an objection to it.
My lord, I think just let me submit. Here, my lord, there is a provision for appeal under section 162C of the rules. They have directly come against the selection.
So they'll file an appeal. Until then, 60 days the appeal will be disposed of.
Yes.
Until then, no appointment. You are agreeable.
My lord,
We'll ask the authority to dispose of the appeal within 60 days.
they will not file yet.
So then let him file objection. We'll take it up.
Yes.
My lord,
Heard Mr. R.P. Sharma as senior counsel appearing for the
in
applicant.
IA number 1221.
In IA number 1221. 1221 or 1221 of 2023. This IA has been filed with a prayer to vacate the interim order dated put the date passed by this court in WPC number so and so. Mr. B.P. Vora prays for counsel for the writ petitioner stroke OP prays for 7 days time to file objection. Prayer allowed. Register to list this matter again on 24th of May 2023 as a fixed item.
May read your lordship. My lord, there is some inadvertent mistakes kept in my writ petition, your lordship. I have filed the IA number. I have
Inadvertent mistake kept in where?
in my writ petition, your lordship, as well as in the order passed by your lordship. I have stated in para 3 and 4 of my IA, your lordship.
Yes, what is your response? Have you gone through the application?
Yes, lordship.
What is your stand?
I just,
This may be changed, lordship.
Huh?
This may be allowed. lordship.
What is the mistake in the order?
your lordship, in the title page, your lordship, the correct village and post office of the petitioner is Simolaguri. But inadvertently, at the time of filing of the petition, it is wrongly typed as Shimalaguri, your lordship. And the correct PS of
Similaguri is-
petition is Kosua, but in the writ petition, inadvertently, it is written as Puk Kosua. And the district of the respondent number 7 is West Karbi Anglong. Simple, your lordship. And in the 9th line of para 2 of the order, your lordship, order dated 24/1/4 of 2023, the words appeal under rule 162C, my lord, it would be 162B, your lordship.
No, C.
Appeal.
It is C. C.
First appeal.
No, C.
C.
C. This one. But in regarding the word of your village, it may be changed.
Second appeal to yes, also.
It no, here is C.
It related to B.
C.
So we'll only correct the order. Read petition, you can't correct it like this. For that, you have to file an application for amendment. That cannot be corrected like this. There is no such provision.
Simple
Only
correction, Your
typographical, huh?
Simple correction, Your Lordship.
Show me the provision. Show me the provision.
Your Honor, Your Lordship, and
Under which provision it can be done?
151 CPC, Your Lordship.
151 CPC.
No, in the IA lordship, their prayer is that to correct the order only, not the petition lordship.
Heard Mr. A. Begum, learned counsel for the petitioner. Also heard Mr. Jacob Goswami, learned additional senior government advocate, Assam, appearing for the state. This IA has been filed with a prayer to correct typographical errors in the order dated 21/4/2023 passed by this court in WPC number 2145/2023. It appears that in the order dated 21/4/2023, the name of the village in respect of which the respondent number 7 was selected for appointment as Gao Pradhan was lot number 11. Then we check the spellings, huh? Lot number 11 within quote. Simoluguri, Simolugori, and the village and the correct PS was within quote Kachua, Kachua, but the name of the village has been wrongly written as Simaluguri and the PS as Kachua. Moreover, the aforesaid village falls under the West Karbi Anglong district. However,
Lordship. In her affidavit, lordship, it is same the wrongly inserted lordship.
yes, that's what I've seen.
No, no, affidavit मेरे को दिमाग में
हाँ?
आपको तो इसमें ना
You have not read the application properly.
Lordship, affidavit, I am not going to, but my friend noticed.
There are mistakes here also. You withdraw it and file a correct one, Ms. Begum. You have realized you have made no mistake. Cut it off. Ms. A. Begum, Ms. A. Begum, counsel for the applicant seek leave of this court to withdraw this. I have with liberty to file a fresh by rectifying the defects therein. Mr. J.K. Goswami, learned additional senior government advocate Assam, and Mr. S. Datta, learned SC revenue are present and do not have any objection if the prayers are allowed. If the prayer is allowed. ISL is disposed of on withdrawal with liberty as prayed for. You file correct application.
I think under item 16.
Lordship, in this case, your lordship last time directed to obtain instruction as regard what action has been taken against the erring officials, lordship. That letter has been forwarded, but that instruction is awaited, lordship. So far other issues are concerned, lordship, so far as his appointment is concerned, that is absolutely nowhere in the record, lordship. No joining letter is there. Even his representation is not there in the official records, lordship.
Then, Mr. Sekhar.
Then, how they could give me the working certificates and forwardings, my lord.
That
So
is
better
what your
give
lordship.
some more time to obtain updated instruction. Now, Mr. Ayed Sekhar and counsel for the writ petitioner also heard Mr. P. Nayak, learned SCPWD, who submits that updated instructions as called for from the department are still awaited, and therefore 4 weeks further time be granted. Where allowed, let this matter be listed again after 4 weeks. Simple order today can be passed dismissing the writ petition. Anything more than that will require very, very subtle application of mind. Let us see what he comes up with. Yes. Yes, Mr. Nair, what is this matter?
I apologize for not being here.
No, that's all right.
This matter pertains to a promotion. The man is an SN engineer, SN executive engineer. Next promotion is executive engineer. Now, what had happened, my lord, in 2015, a FIR was.
We are pressing for an order today.
My lord, on the last occasion, my lord had fixed the matter.
We'll take it
Interim will not work out, my lord. There has to be a final disposal in the matter.
Second up.
Or can it be on any other day? Today, that,
Yes.
any other day?
We also have a full court meeting from one
Lordship,
fifteen.
my lord will have it on any day.
But we only need to place the authorities, nothing else.
My lord will have it on.
Mr. UK Nayak, senior counsel is present of the petitioner, Mr. P Nayak, learned SCPWD is present on behalf of the department. On the request of learned counsel for both the sides, the registry to list this case again on 23rd May
Not-
2023 as a fixed item.
Much.
So the full court meeting went on. That is why there is a little delay in sitting the report.
If your lordship, gateway goes to case
I'll
71.
just
present my case shortly, your lordship. Since your lordship is taking up for disposal. So I'll just present my case and the learned senior counsel can then make it.
Yes.
Lordship, the short issue, your lordship, which calls for a lordship determination is whether the petitioners are entitled to copies of the final answer key and their OMR sheets, your lordship, since they had participated in the combined competitive preliminary examinations, which is now concluded. We had filed applications, your lordship, before the authority, as well as submitted a representation. Then at that relevant point of time, they had verbally informed us that till the entire means examination, till the selection process is not over, in fact, we cannot give you copies of the OMR sheet, nor will we publish the final answer. So in that circumstance, we filed the report. Then we had only made a statement. Now that's it. The contention which was verbally communicated to us, now they have placed it on.
So where is their application seeking OMR?
We had submitted applications under the RTI. The receipts are at page number 57 onwards, your lordship. All of them are enforced. So now what they have stated in the affidavit, your lordship, is
yes.
They have stated in the, I'll just take your lordship to the affidavit, which the relevant portion is at page number 67. This is by the Secretary of the Public Service Commissions. Page number 67. I am reading from paragraph number 8, your lordship. At the bottom, that with regard to the amendment made in paragraph 8 of the writ petition, the dependent begs to state, this is important, that the application submitted by the petitioners are under consideration of the authority under the Right to Information Act 2005. Now, your lordship, at paragraph number 9, what they have stated, this that with regard to the amendment made in paragraph so and so of the writ petition, the dependent denies the same to be wholly correct and true. It is further denied that the judgment of so and so is with regard to the means examination. I will not trouble your lordship with the entire thing. However, if a specific case is made out where the honorable court finds that public interest requires furnishing of information sought by the petitioners, the commission is ready to comply with such orders passed by the honorable court in this regard. So they have said that if public interest is in our favor, they will comply with any directions passed. At paragraph number 10, strangely, the commission has said the commission differs, perhaps it should be differs from publication of final answer keys, as such publication leads to an endless process as self-styled experts making contrary claims and creating a deadlock, jeopardizing the timely completion of the entire examination process. The petitioners can get OMR sheet of the combined competitive examination 2022 after completion of the combined competitive examination 2022, as it is a common practice followed. Now, your lordship, a common practice which is against transparency and the right to information, which is otherwise a right under Article 21. There has to be an established practice, your lordship. It cannot be a convention. There is no rule, your lordship, which prohibits that OMR sheets cannot be granted to the petitioners, cannot be given. In fact, your lordship, earlier there were several petitions.
Just a minute, Mr. Pathak.
Lordship.
Why should the OMR sheets be given to you? First answer
Because
that.
since as candidates in the examination, your lordship, since we have become unsuccessful, we have a right to know, your lordship, why we were unsuccessful.
Correct. You have a right to know.
Yes, your lordship.
But why right now? Why not after the exam is over?
Because
Answer
your
that
lordship,
question.
if apart from that, right, your lordship, we also, if the OMRs have been incorrectly evaluated, your lordship, we can explore the legal remedies available to us.
You can do it after the mains is over.
But your lordship, otherwise, your lordship, there is no justification for sitting over that.
No, Mr. Pathak, tell us one thing. How many students appear in the prelims examination every year?
It's in lakhs.
What is it?
I do not have the exact figure.
75,600.
Sorry?
75,632.
So today, if we pass an order like this, blanket, tomorrow if 75,000 students come and says that give us our OMR, you think the APSC will forget everything and go on giving OMR.
Because your
You have
lordship,
to make out a prima facie case.
no, your lordship. the
You
court-
just want to know what has happened to how well you did in the exam. That's all.
No, apart from that, your lordship, if our answer scripts, because unfortunately, your lordship, the APSC, your lordship doesn't have the soundest of records, your lordship, as far as the answer keys and evaluation is concerned. For example, in 2019, as many as we all know about it, I'll not like to go into it. Now, your lordship, when there is a-
Please understand the question first. Otherwise, you will go on making your submission. It will not. The core issue here is
Lordship.
you are just 10 candidates
Nine.
who have appeared in the prelims.
Lordship.
You did not qualify for the mains.
Yes, your lordship.
Now you want them to give you the OMR sheet
Yes, your lordship.
because you are not agreeing with their evaluation.
Yes.
But you can't say why.
No,
According to you, you don't have any answer why. You are only saying that because I have failed, so I want them to give the OMR.
perhaps
That's-
we have been right. I have rightly not been qualified, your lordship, but at
That's
least we
right,
have a right.
that's right. So you don't make out a case on merit, prima facie showing that these are the reasons why you feel there is an anomaly in the selection process. That's not your case.
Yes,
Your
that is
case
not
is
my
that
case.
I have failed, so now you have to give me the OMR.
No.
They are saying, we'll give you the OMR. You are saying, no, give it to me right now.
No.
They are saying, right now we are busy with the mains exam. Please wait for some time. As per the rules, we have preserved it. We'll give it to you. You are saying, sorry, since we have failed, we want to know it right now. And after that, if you find something is there, we want to file a case against you right now. Why should the writ court entertain
No.
this kind of a
We
prayer?
are not saying that we are going to, that we are not. even
Whatever
contending-
be the reason.
Since we have submitted applications under the RTI Act also, your lordship, and they are saying that they are going to give the documents to us. The section 7 of the Act specifically says that within 30 days of such application be filed, they either have to accept the application and give us the information, or they have to reject it. Now, here is a case, your lordship, where they are saying, yes, we accept your application on merits, but since we have a convention of not giving it, we are not going to give.
Then you challenge that order.
But no order has been passed, your lordship. As of today, your lordship, I am forumless.
So you want a direction that forthwith they should give you the OMR.
No, at least what,
That direction this court is not passing.
no, lordship, because otherwise I have a right, your lordship, under the RTI Act, under the Right to Information Act. They can reject our application also under that act, but they have not done that. They are saying,
They'll say that you pass an application under the, you pass an order on the application under.
very well, let them pass an order to applications will be satisfied. Because there is a man.
You do it.
In fact, my lord, that is premature because we have getting as per section 7, we are getting 1 month time. Prior to that, they oppose this one. And
No,
in
they,
fact-
because now they have set it on affidavit, your lordship. It might have been premature when we had filed it. Now it is on affidavit.
No, but now it is sub judice matter. They can't act.
And for his satisfaction, my lord, I have annexed, my lord, what is there, why they have not failed, my lord. Even one of the candidate, my lord, he has not written, your lordship kindly page 71, my lord. For his satisfaction, I have mentioned everything, my lord. Why they rejected. Page 71, my lord, is a petitioner number 1, last column, below cutoff GS1. Petitioner number 2, serial does not, series not darken. That is very important, my lord. Series not darken. That is why it's not been evaluated. It is already mentioned in the, my lord, OMR sheet very clearly. And that is why, my lord, all the candidate getting 20-minute times to just to fill up the OMR sheet, my lord. Because it was always provided just 20 minutes ahead. So they have to already there are 3 instructions in the admit card, in the OMR sheet, clearly mentioned. There's instruction also. You are then, my lord, they have to go through the instruction and they have to darken the appropriate box, my lord. Otherwise, it will not be digitally, it will not be counted, my lord. So that your lordship kindly see one of the candidate, petitioner number 3, below cutoff, petitioner number 3, sorry, my lord, series not mentioned. He is not mentioned the series. There are 4 series, A, B, C, D. So he has to mention the series and darken the appropriate box. That is not been done. Then, my lord, serial petitioner number 4, below cutoff, petitioner number 5, series not darkened, petitioner number 6, below cutoff in GS1, petitioner number 7, below cutoff GS1, petitioner number 8, incorrect darkening the rule number. Even if rule number was not properly, my lord, written, He is going to be administrative officer of the state of Assam, my lord. He getting 20-minute time to fill up the form, my lord, fill up the OMR sheet. That is also not correctly, my lord. So even, my lord, this supplied to him, my lord. What will happen to him, my lord? Can my lord direct to invalidate again, my lord?
Yes. I'm not even at this moment, your lordship, we are not asking.
No,
for any
ultimate, I say
gratification.
ultimate.
একটু type করে পারবো, এই-
Nor are we challenging it. your lord.
Mr. Pathak, I think
And
that should
regarding
be
the
enough.
at least the final answer key, that should be published, your lordship.
No, that
OMR's
one in due
OMR's
course of time,
final
I
ans-
will go into.
Final answer key, your lordship, something as
Definitely.
vital as the
Your
final answer.
prayer is for
Both, for both.
OMR.
OMR as well as the final answer. Prayer is at page number 15, your lordship. The second prayer is regarding the final answer.
You're not publishing the final answer key.
Yet, not yet, my lord.
When will you do it?
In due course of my lord, we'll publish it.
No, what is the due course?
Due course, my lord, because we are now busy in that, my lord, because if PI publish after completion of the process, my lord, we'll going to it. In fact, we affidavit stated it, man. In completion, we'll publish it, man.
When I'm just, there was a Supreme Court, because I was looking
No,
for judgment.
Supreme-
No, what I was looking for judgments to see if these issues have been considered by the Supreme Court.
Then
There are a line of judgments where the apex court has held that when candidates ask for the answer scripts, your lordship, they should be given, except where giving of that information, your lordship, leads to disclosure of the person who has corrected the answer scripts. For example, in the UPSC, there is a system of.
Mr. Pathak, the other day when the interim, whatever observations were made,
Yes,
this court was hoping that there are some strong prima facie case the petitioners will come up with. These are matters which can be sorted out in 2 minutes. The Supreme Court has said it should be given, and this court will say. But Supreme Court has never said it should be given within 3 days of filing the writ
has
petition. Right. They are also saying it will be given, but we don't want to do it right now before the prelim mains exam is held. What is wrong with that submission? You are not being able to point out.
Well, lordship, what will happen is, lordship, for example, now they are saying that they are not going to give it to us right now because if.
And you have not challenged the rules?
No, because there is nothing in the rules, your lordship, that it cannot be given to us. That is why, your lordship, we are before your lordship. If there was something in the rules, if there was a rule, a notification, even an administrative order, that till the entire process is concluded, we cannot give it. There is nothing. What they have stated on affidavit is it's common practice. Now, how can we challenge a common practice, your lordship? That is why we are before your lordship.
But you are not being able to make out a case on facts. Why there should be an interim mandamus issued to them to give it to you right now?
Because, your lordship, if they have been incorrectly evaluated, your lordship, since the exams are on
But
the.
where does the question arise now? You have accepted that this is correct. You don't want to file a rejoinder. You said that. So if that is correct, what difference will it
This
make?
is correct according to them, your lordship.
No, but you have not
Unless
filed
I-
any.
Unless I have the OM, because as of now, your lordship, I
No,
cannot
no,
say.
their stand taken here. You are not responding to this. You are not challenging. They are saying so and so because of this so and so. There are different reasons given for which different petitioners have been disqualified.
Yes, your lordship.
In the morning, you said you don't want to
Yes.
file a rejoinder.
Yes, your lordship.
That means you are accepting this. This is how law operates.
Because, your lordship,
Whatever be the reason.
To rejoin to this, your lordship, I'll need some materials, your lordship. Now, what I say, I cannot, there are no materials on which I can
There are
contest
no
this.
materials for your petition. Forget the rejoinder. Petition itself is completely speculative.
No, petition, your lordship, the petition is not speculative, your lordship, because I'm not asking for evaluation. I am only saying I have a right to receive the OMR sheets. They are saying you may have a right, but you do not have a right to
It
receive
is
it now.
understandable that these exams are done under very, very tight cover of secrecy, confidentiality. The candidates don't have much information. That is fine.
Lordship.
But just because that is the case, you cannot just open the Pandora's box merely because somebody comes and say, hey, I should have got 65% and I've got 60%. Everything is sham, throw it out. That can't be the way. You have to say some reasons why you feel that you have been deprived. There's some malpractice. If you can't make out the case, the writ petition will not be entertained. As simple as that. That is how the law operates. Otherwise, there will be no end to this. Tomorrow, if every examination, if the law is laid down, everybody, in every examination, there are lakhs of candidates, only few thousand or maybe few hundred makes it. Rest of all will come to the court and ask for a stalling the process.
But nobody is asking for solving the process, your lordship, and as far as coming to.
We are not concerned about it. We are about the principle of law. What is the principle you are relying upon? Tell us that.
The principle is, your lordship. that
If you can show the principle and fit the facts in it, I'm willing to pass any interim order that is justified.
First, your lordship, why we are apprehensive that our answer scripts were not properly evaluated. First,
No, you are not saying that.
no, because I cannot say that, your lordship. Why we are apprehensive? Because it's again, that's also made a speculation, your lordship.
So you cannot even make out that case.
Why
Your
we are-
case is only simple, straightforward case of RTI application. That's all.
RTI application, which they have not, they're sitting over.
They are saying they'll give it to you within 30 days. That's the case, nothing else.
If that is recorded, your lordship, I'm satisfied, your lordship. If they are willing to give it us within the time period, that is. I'm
It's
satisfied.
better that you don't press this matter any further.
If that
It
is.
is highly prejudicial for your clients.
If
We say that we replied in Sabin, because RTI application is there. We have not filed RTI application, there is a separate procedure money. If I am not giving, they have to file
Correct.
appeal.
So that's what I'm saying. They should have pursued that track.
Yes, because before that they have filed appeal.
to pursue that, your lordship, then we have been verbally informed. Now it is on record that they are going to give it us, but not on time. We might have an alternative remedy, but as of now, your lordship, that is not efficacious. We will go there, we'll pursue it. We might get, we are confident that we'll get it at the end of the day, but because of the lapse of time, your lordship, if, for example, now after the answer keys were
The
published.
fact is, you are even hesitating to tell the court that if you can fish out something from the RTI application, you will ask for a stay of the mains exam. That's your urgency. Why don't you argue straightforward?
Lordship.
That is your agenda, but you are not saying that you means not you, your clients.
Lordship.
If that agenda is not bona fide for which you can't even argue,
No,
give it up.
Lordship, right, as of now, your lordship, without materials, your lordship, I cannot make that submission that we are going to ask for a stay of the mains exam.
That's correct, but that's the reason for the urgency.
That
You want to stall the mains.
No, your lordship.
That's why.
We don't want to solve the mains.
All right, then we issue
What, lordship,
Here it
just
is.
one final submission. What we want, your lordship, is if our answer scripts have been incorrectly evaluated, because after publication of the results, final answer key has been, they have said that two answers were wrong.
Ifs and buts, we can't pass.
Because your lordship, after publication of the result on 12th, your lordship, on 17th, they have said three answers were wrong. Now we do not know, your lordship, without our OMRs being given to us and the final answer key being published, that whether those marks have been given to us or not. Now, when they themselves have not said that the answer script, the results which were published on 12th, everybody's whose answer scripts were evaluated, those have been correctly
evaluated. That's all. Anything else?
So just two documents, your lordship, two documents. I know the merits of my case, your lordship, 56, your lordship, page number 56.
You know it.
Yes, your lordship. I know it's a page number 56 for once, your lordship.
Yes. Mr. Pathak, every case they say can be won. It all depends on what is the projection made at what point of time and on what material basis.
Lordship.
That is the name of the game.
Lordship.
Nothing else.
Lordship.
If you find a particular projection is not working out, you have to rethink what is to be done here. Pushing hard on a projection which does not find favor with the court for reasons disclosed does not make any sense. I am again and again asking you, you can get your OMRs, final results, but why are you pressing for an order immediately?
Because
is it that if you can fish out something from it, then you want the mains exam to be stalled, you should get back to it and then proceed in the matter. Is that your case?
We do not.
You are saying no to it?
We would not want the main exam to be stalled, your lordship, but we definitely like to participate in it.
That's why you want to get into the mains exam.
Not solve the.
Then you have to make out a case on facts.
On facts, your lordship, why we are not able to make out a case. Now, I'll just take your lordship to page 56 for once.
That is a roving inquiry. That is a fire in the shot in the dark. That just because I didn't get, let me try, go to High Court, file a writ petition and see if I can fish out something. That is the only reason. You have nothing to show that there is a case made out. You are only saying that we want this, because we are not happy with what has happened. Can that be being unhappy with something? Is it equivalent to violation of somebody's right? What are the principles in a writ petition? You can file a writ petition to enforce your fundamental and legal rights.
Yes.
Not because you are unhappy or you are sad or you want to teach somebody a lesson or settle a score. You can't do that. What else is this?
Lordship, here
what is the right that you are seeking to enforce?
The right we are seeking to enforce is through correct evaluation, your lordship, and
Then
transparency.
show me that there has been wrong evaluation.
Why, page number 56 for once, your lordship.
Yes.
Because that is the only document now which has been disclosed to us. Page number 56 is a notification of the date is important, 17th of April. Where it has been stated, it is hereby notified that the cutoff marks are against the respective categories in the combined exams are as follows. This. General studies 1, number of questions where provisional answers have been corrected 3, number of questions where marks given to all candidates as there was no correct option 2. General studies, number of questions where provisional answers have been corrected 2. It is also notified that so and so candidates have by securing the minimum qualifying marks of 33%. Now, your lordship, the results were declared on the 12th. Till 12th, there was only a provisional answer key. We did not know that 3, 5, 7 answers were wrong, your lordship. Now, after publication of the results, on 17th, they say that 7 answers are wrong. We do not know which 7 answers are wrong. We do not have the final answer key. We do not have the OMR sheets to know that if these answers which are wrong, the marks have been given to us or not. Now, if the competitive examination.
So, Mr. Mahanta, where is the final answer key? Where is the final answer key? You have brought it today?
Yes. But there is series, my lord. A, B, C, D. My lord, I'll answer to that, my lord, if you lordship, my lord. 26.
No, what if we allow all of them to have a look at the final answer sheet?
No, before that, my lord, your lordship. Yes, my lord, that is there, my lord. In other cases, my lord, I take it, my lord, it is in seal cover, it is been open to the court, my lord.
Yes.
And my lord, day 1, my lord.
There is already an order by this honorable court in my case to produce the answer key, Lord. We are entitled.
That is what I'm saying.
That is there, my lord. No, my lord, before that, my lord, on that day, my lord, our affidavit was not been taken into consideration. My lord, I have to, in his case, I will make my submission, my lord. Here in this case, my lord, what my learned friend says, my lord, my learned friend says that, my lord, they came to know only in, my lord. Your lordship kindly see what happened in this case when on 26, my lord, March, we published the answer key, provisional answer key. Then we sought for a, my lord, any objection. There is a procedure, my lord. Any objection from any candidate, they can file within a week. That we will send it to, then we will send it to expert. If any objection. So whatever the objection we have received, we collect it and send it to the expert. After, my lord, examining by the expert body, then, my lord, final answer key was prepared. So hey, that final answer, after that final answer key, this order was passed. So that, your lordship, kindly, why I am submitting, my lord, they are clubbing all, my lord, cases in a one petition. They try to create, because your lordship, kindly, I have already stated that one of the petitioner, my lord, he's not correctly written the rule number. He's not correctly written the his series. He's not correctly written the say A, B, C, D. These are not validly examined, my lord. That's why they are showing the 0. Your lordship, kindly see in my compiling statements, I have stated they are getting 0. Because it is not been, they have not properly filled up the form. So on those MR sheet, they are getting the MR sheet. What they will do, my lord? We cannot again evaluate it, my lord, because their fault they have not done it. There is a clear instruction. You have to darken the appropriate box. Otherwise, it will be not evaluated. That is clearly mentioned in the OMR sheet, my lord, in very first page. So my submission before your lordship, if your lordship, my lord, says that yes, produce it, my lord, tomorrow another will come, my lord, it will be very difficult for us to complete the examination, my lord. That's why, my lord, I am submitting before your lordship. As per the court order, my lord, I place before your lordship. It is in the seal cover, my lord. But in that case, my lord, I make my submission, my lord. It is also that retribution is not maintainable as per the High Court also. Your lordship, kindly see, they cannot composite, my lord, composite grievance, my lord. They cannot file in a one single. If file, they have to file a separate affidavit. That is the law, my lord. Your lordship, kindly see. Your lordship, kindly see the one High Court. That's why, my lord, in other case, my lord, I have, my lord, preliminary objection I have made, my lord. But here in this case, my lord, he said that only I want to my seats, all are same. But now, my lord, rejection order I have stated, my lord. Suppose, my that where he is not fill up the, my lord, rule number, if I produce it before your lordship, what result will get in future? So for this, my lord, that's for his satisfaction, my lord, came to the before this honorable court giving this all, my lord. Because last 2 days, my lord, we work out everything. Out of 75,000, my lord, we have to collect it, my lord. It's very difficult for us. Even then, my lord, complying the High Court order, my lord, in time I have filed it, my lord. Your lordship, kindly once see the High Court rules, my lord. Chapter 5A. I try to, my lord, remove the APSC, my lord, and transparency. Always, all level, we try to maintain the transparency, my lord. High Court rules, chapter 5A. rules governing, has your lordship got in, madam?
Yes.
Rule governing application for direction, order, or writ other than the nature of the habeas corpus under Article 226 or the Constitution of India. Any application for direction in order to read under Article 226 of the Constitution of India or an writ or habeas corpus shall be drawn up in the form of contained in the schedule, the chapters, then shall be compared by the any affidavit verification fact also. Separate application should be filed for each individual where interests are not identical. Even if there is no one common order covering several cases, under the facts of each case should be separately supported by affidavit. So here, my lord, there are 9 petitioners. One petitioner, his grievance is something different. Other is different, my lord. How he can swear in behalf of the others, my lord?
This rule, your lordship.
Let him finish.
So, my lord, that's why I'm submitting, my lord. And this petition, my lord, they are only filed. Yes, we admit it. In due course of time, what is the there? He says that there is no rule. Yes, there is no rule to give him also. Give it answer script, my lord. So that's why, my lord, OMR sheet and that final answer key will be provided in due course of time. We made in the statement in the affidavit, my lord. That's my submission, my lord.
Yes, any answer?
Yes, regarding this question on the maintainability of the petition, Rule 1 would have been applicable, your lordship, if we had challenged the evaluation of the answer scripts or that we had challenged the examination in any manner. As of now, your lordship, the only grievance projected by the petitioners is that the information that they had sought for has not been contributed. So they are identically placed, your lordship. And regarding this requirement of payment of court fees, which is there in Rule 1, that they have individually paid the court fees separately, your lordship. So Rule 1 would not be applicable in this case. And now, as the learned,
You have made the RTI application seeking the OMR sheets.
yes, the RTI applications for the OMR sheets.
All right. You have heard Mr. KP Pathak, Learned Counsel, appearing for the petitioners. Also heard Mr. TJ Mohanto, Learned Senior Counsel, assisted by Mr. PP Datta, Learned Counsel, appearing for the respondent numbers. Respondent numbers 1 to 4. The 9 writ petitioners have joined together to file this writ petition, seeking a writ of mandamus directing the respondents. No, you write like this. The 9 writ petitioners herein had all participated in the combined competitive preliminary close examination, 2022, conducted by the Assam Public Service Commission, APSC, close, held on 26/3/2023, full stop. However, after the results were declared, the petitioners did not qualify for participating in the mains examination, full stop. At this stage, the 9 petitioners have approached this court by filing the instant writ petition, inter alia seeking a writ of mandamus directing the respondents to furnish them with the OMR sheets of the CC preliminary close examination, 2022, and also the final answer key, full stop. Taking note of the grievance expressed by the petitioners, this court had passed order dated 3/5/2023, directing the APSC to file preliminary affidavit responding to the grievance of the petitioners. Accordingly, the respondents have filed preliminary affidavit dated 11/5/2023. Full stop. Responding to the grievance of the petitioners that their applications filed under RTI Act 2005 seeking copies of the OMR have not yet been responded by the APSC. It has been mentioned that the OMR sheets of the petitioners have been preserved and the same will be given to them after conclusion of the combined competitive examination, 2022, as it is a common practice followed by the APSC. Insofar as the merit of the case is concerned, the APSC has annexed a copy of the APSC has annexed a statement to the preliminary affidavit indicating the standing of each of the 9 petitioners to submit that many of the petitioners did not qualify because of defects in filling up the series stroke, incorrect darkening of roll number, etc., whereas some of them could not obtain the minimum cutoff mark in GS1 paper. Full stop. The details furnished by the APSC in the aforesaid statement marked as Annexure 1 to the preliminary affidavit is reproduced herein below. Quote full stop. By referring to the table, Mr. Mahanta submits that the cases of all the petitioners are not identical, and therefore the writ petition itself is hit by Chapter 5, Roman 5A, bracket numerical 1, rule numerical 1 of the Guwahati High Court Rules 2022, and hence liable to be dismissed on such count alone. Full stop. Mr. Pathak submits that he does not intend to file any rejoinder against the preliminary affidavit, but his basic argument is that the APSC should be directed to forthwith hand over the OMR sheet to the petitioner and also to publish the final answer key. Full stop. After a careful scrutiny of the averments made in the writ petition, this court is of the opinion that the petitioners have failed to make out any prima facie case for issuing a writ of mandamus directing the respondents to hand over the OMR as well as final answer key forthwith. More so when it is the pleaded stand of the APSC that the OMR of the petitioners will be preserved and furnished to them in due course. Full stop. If the petitioners are aggrieved by failure on the part of the APSC to give proper response to them in respect of the RTI query, then the remedy would lie elsewhere, but not in this writ petition. Full stop. It is no doubt correct that in matters of this nature, the APSC would be required to maintain absolute transparency, and the students would have a right to know as to the fate, have a right to know as to how they have fared in the examination. But their right as above cannot come at the cost of disrupting the entire examination process by compelling the APSC to furnish them with all particulars forthwith, even when no prima facie case has been made out to indicate any anomaly in the selection process. Moreover, after going through the details furnished by the respondents pertaining to the 9 writ petitioners, I find force in the submission of Mr. Mahanta that all the petitioners are not identically situated, as many of them had incurred disqualification, not due to the marks scored by them, but for other reasons. First of, Viewed from that angle, this writ petition cannot be maintained in the facts and circumstances of the present case. Full stop. Therefore, by granting liberty to the petitioners to pursue appropriate remedy if the OMR as well as the final answer key is not made available to them within a reasonable time, this writ petition stands closed as not maintainable in the facts and circumstances of the case. What is the other matter?
53.
In this case, your lordship, on the last occasion, was pleased to direct the APSC to produce the answer key.
My lord, may I clear one point before your lordship, my lord? Because I have here also, I need affidavit, my lord. My first contention was regarding preliminary objection regarding maintainability. My lord, in maintainability, he has yet to answer, my lord. So my submission before your lordship kindly go to the first decide the maintainability, but then my lord, your lordship open it. But as pursuant to the order, I made it before your lordship can, my lord, open it, but for satisfaction of the court, my lord. But regarding, my lord, I'm very first para, my lord, regarding maintainability, I have mentioned, my lord. Yes, till today, he has not been answered, my lord. Here also, my lord, there are 10 petitioners, series are different, pairs are different, and very interestingly, when, my lord, answer key, provisional answer key was published, then there is a notification that I have already given, my lord, that any complaint by any of the candidate within 7 days, 5 days, my lord, they can file application. Out of these 10, only one, my lord, petitioner has filed objection. Only one, my lord. And very unfortunately, that person, that petitioner number 5, my lord, your lordship kindly see Dhurbajuti Nath. Sorry. Oh, sorry, petitioner number 7, Manoj Das. His, my lord, answer script was not been examined because he is not darkened in qualifying paper. If your lordship take up my lord affidavit, my lord, clearly I have mentioned it in several occasions. Even my lord, OMR sheet clearly yet indicated answer sheet without marking serial shall not be evaluated. Page 191. That I'm submitting regarding their different pair, different my lord grievances, my lord. By clubbing together, they filed this, my lord. So it is clear violation of that, my lord. There is no separate affidavit they have filed. So that's why, my lord, he has not been answered, my lord. 1 year ago, he has get it, my lord. But till today, have not filed affidavit, my lord, on that point regarding maintainability, my lord.
So why do you say this writ petition is not maintainable?
Maintainable because, my lord, their grievances are clubbing together. All, my lord, petitioner number 1 grievance is different. Petitioner number 2 grievance is different. Petitioner number 3 grievance is different. He has no common pair. So since grievances are different.
May I just explain one thing, my lord? When we filed the writ petition, my lord, what was the picture before us, my lord? The picture was that, my lord, we participated in the preliminary examination, my lord. They have published the provisional answer key. Then they have issued a notification saying that in GS2 paper, we have corrected 5 questions. They don't say which are the questions. In GS1 paper, we have corrected 2 questions. They don't say which were those questions. Now, thereafter, they don't publish the final answer key, my lord. My lord, I'll place the Supreme Court judgment wherein the Honorable Apex Court has very clearly said that you are bound for making the to maintain the sanctity of the process, fairness of the proceeding, you are bound to publish the answer key, final answer key. They haven't published the final answer key. My lord, definitely there will be, my lord, prejudice among the candidates. The petitioners who, my lord, lordship will kindly appreciate one thing. There is a series paper that is given to us to answer. Question number 1, A, B, C, D are the options. When we answer question number 1, we tick mark in our question paper that I have answered so and so. So that is our record. Now,
as on date, they haven't published the OMR, my lord. They have not furnished the OMR. My lord, in that context also I make submission. Now, in one hand, you do not disclose the questions which you have corrected. You do not furnish the final answer key. In that situation, what is our...
Why are you forcing the court to dismiss this petition? The different petitioners are, that's what he's pointed out.
My lord, that is what I'm trying to say. My lord, when the date when we filed the writ petition, our cause of actions were same. We, my lord,
Now withdraw it and file separate petitions. Then we can go into the
with
merit.
all due respect, my lord, these are students, my lord, 25, 26 years old students, my lord. Lordships may not be inclined to relegate these students to another litigation on the basis of objections of, because this petition number 1, 2, 3 has been, my lord, rejected on different grounds. This fact has come by virtue of their affidavit.
Are you alleging malafide against the APSC?
My lord, there is no question of malafide. There is gross illegality in evaluation, my lord. That is why they...
Show it. Where is it? Show me.
My lord, I have given my marks in, I have shown the marks in my para 12.
Where is the petition? Show it from the petition.
Para 12 of my writ petition, my lord. They are saying contrary to this, and lordship also appreciate one aspect. On
You means 9 of you.
Yes,
10
my
of
lord.
you. 10 of you.
10, my lord. My lord,
All
lordship
10
will
of you have given your marks.
Yes, my lord.
Where is it? Show me.
Para 12, my lord. Page number 12. And on the last occasion, this honorable court passed an order that you have to publish the final answer key.
No, that is not the order, please.
You have to, no, I understand. Lordships ask them to bring the final answer key. I'll persuade your lordships to publish the final answer key. I am having a Supreme Court judgment. Lordship will kindly have
No, you are interested for your client or others also.
No, my lord, I am.
You have a look at the answer key.
Yes, my lord,
that's all.
lordship will give it to me, my lord.
Let him have a look at the
Lordship
answer
will
key
give it to me, my lord.
and see what he has to say. What is the
Yes.
problem with that?
My lord,
What is the problem with that?
regarding what?
Let him have a look at the answer key.
My lord, that is why I am submitting. Even my lord, they knows it. The petitioner number 1 is, my lord, CL is different. Petitioner number 2, CL is different. Petitioner number 3, CL is different. So that's why they are clubbing. That's why I'm creating a preliminary objection, my lord. Your lordship kindly see, if it is a serial number C, all series, my lord.
They'll have the
Therefore, my
they
lord.
need it too. They
My
will not
lord.
disclose the regions. They'll come up with the regions in the
No, that's why I'm
and now they'll take a stand that no. We have rejected all your cases in different footing. So you will have to come up with separate writ petition now. Initially, all right, you don't have your grievances were common. Now, since we have disclosed that different writ petitioners were rejected on different grounds, now you have to file a writ petition separately. And it be appreciated, my lord, in a writ proceeding, my lord. These are 25, 26-year-old students, my lord. They have participated in a selection process, and the APSC is saying that this court is making submission before this court relegate the students to another round of litigation, my lord.
So what is really your case, Mr. Das?
My case is they are duty bound to produce the answer key. Lordship will kindly have the judgment I have given, my lord. Para
So
26.
they will produce the answer key and will close the matter here.
No, my lord.
Why?
There are,
We will not allow you to develop a case on the basis.
I'm not developing, my lord. My
That's
entire case rests in para 12. My
What is
entire case rests in para 12, wherein I have given my marks.
What is the para 12? Let us see.
Lordship will kindly see.
What is your case? You have, I have seen there is a table in para 12.
Yes,
What
my
is the
lord,
case?
that is what I am trying to satisfy. My lord, in the question paper, if your lordship kindly see the question paper once, my lord, series. I'll just show, my lord, from the question paper itself.
Mr. Das, I am asking you, what is the case you have made out in para 12?
Okay, my lord, I'm just saying. My lord, as per para 12, my lord, we have scored in, say for example, my lord, petitioner number 1, cutoff mark is 54.5. Lordship will see. In GS2, I scored 78. Qualifying mark is 66. In GS1, I scored 67. Cutoff is 54. I am in for main examination. Their marks, the marks now the APSC is disclosing in their affidavit. That is, my lord, I understand and appreciate there is a difference of 1 or 2 marks from my calculation. Last time my senior, the learned senior counsel has made a submission that we failed to calculate the negative mark. My lord, we
So
calculated.
what is this at serial number 5? In the table in para 12,
Yes,
Dhruva Jyoti Nag.
Dhruva Jyoti Nath,
He has scored 100.5 out of 100.
he scored, no, my lord, it was not, no. I'll just place my lord. He scored, the total marks were in GS1,
Yes, 100.5.
200 marks. GS1 total mark is 200 mark. GS2 total mark 200 mark. So out of 200, he scored, Dhruva Jyoti Nath, in GS2, he scored 101.25. And in GS1, he scored 100.5. That is the material. Why I am questioning the decision of the APSC?
And who is the person scoring less mark than you who has cleared? Has anybody cleared who has scored less mark than him? But if there is a defect in darkening the square, etc., then he will not make it.
So far as my lord, defect in darkening the, my lord, the bubble is concerned, my lord, that is a totally different aspect altogether, my lord. I'll make legal submission on this regarding
you
bubble.
mean to say if the score is there, even if there is defect in darkening, that doesn't matter.
Yes, my lord. My humble submission is that, my lord. I'll satisfy your lordship with
Hear
that.
the matter then. We'll issue rule and hear the matter.
No, my lord. Lordship will kindly appreciate one thing. At least the answer key which your lordship directed on the last occasion. Your lordship was pleased to direct on the last occasion. Those answer key may be given to us so that we know what were the questions you corrected in GS2 paper and what were the questions you corrected in GS1 paper. We are entitled to that.
Achha, Mr. Mohanto, what is the big problem with publishing
just
the
want
answer?
to understand.
Answer key is always meant to be published.
Lordship will, the judgment.
That, my lord, yes, we'll take instruction when it will be published. I can.
No, we'll direct that you publish it within.
No,
2
my lord,
days.
you didn't form it because your lordship kindly fix it tomorrow. I'll take instruction on that.
What is the problem in publishing the answer key?
Publishing, my lord, your lordship kindly see at present, my lord, because of the, my lord, it will be chaos, my lord. Because nobody will be, my lord, satisfied in their mark, my lord. Even, my lord, they will calculate in different way because we have to go by the statement of the, my lord.
Maybe,
My lord.
but only if they make out a case.
That's why, my lord, if you, I place before your lordship, there are several series, my lord. All series I have before your lordship. And my lord, what I am going to submit, my lord, your lordship kindly in para 15, he knows their ground of rejection, my lord. He himself stated.
No, Mr. Mahanta.
No, my lord, no, my lord. This is a statement.
These
No statement.
answer keys are
No, my
meant
lord,
to know, let the candidates know,
my lord,
that these are the correct answers. Therefore, they should figure out where they stand on merit. That is the purpose.
Supreme Court say they will suffer in silence.
What is the problem in?
My lord, I'll address your lordship tomorrow, my lord. Can we fix it tomorrow, my lord? On that point, my lord.
Yes. Well,
Yes,
other things.
definitely we are going to publish
Other
it.
things I may not agree with them, but one thing is for sure, you can't say that. there is
Exactly,
answer
my
key.
lord. I do agree with your lordship.
Nowhere it has happened till now. Nowhere in any
No, not that, Lord.
exam. My lord, in 2009, they have same 90 questions. They are under question. 90 question answer key was wrong. They have given OMR. They have published answer sheet. I'll produce the order sheet. That repetition is still pending, my lord. The persons, the candidates, they were allowed to appear in the main examination. They have cleared main examination, my lord. Now those repetitions are going to be infructuous because of the subsequent success. 90 questions, those questions were wrong. They have published.
Anyway,
answer
Mr.
key
Mahanta,
OMR.
what I am saying is you are
No, my
a
lord,
senior counsel.
I'm submitting.
Just a minute.
Even, my lord,
What I am saying is, regardless of anything else, these are ultimately public law committee, is it not?
Absolutely, man.
So you have prepared an answer key.
Final answer key.
Final answer key. Just because somebody might file a case, you can't say that we'll not publish it. Let them file a case.
That's not that.
There are
We
judges to see.
Even,
whether the
even in
case-
earlier repetition, I have said that in due course, sir, everything will be met. But your lordship,
Why
what
due
due
course?
course?
Why not now? Why not now? I may not agree with them that immediately the OMR should be given to them. But I think they have a right to know what is the correct answer.
My lord.
And how they have featured in this. How can the students be kept in the dark from that? That is difficult to
No,
accept.
usually, my lord,
Injustice
even
in
in my lord,
silence.
that is the procedure we followed in the earlier exam also, my lord. In APSC also, my lord, after the exam, it is published, my lord. My lord, that's why I'm saying. That's why, like it tomorrow, my lord, I'll address your lord.
I'll clarify one aspect. the Honorable Supreme Court has said, when there is a written examination followed by viva voce, if that is the situation, don't disclose the answer key, because if you disclose the answer key of the written examination, that might create a prejudice in the mind of the candidate that there were prejudicial marking in the viva voce. But when there is a written examination only, not viva voce, followed by no viva voce, you are duty bound. Supreme Court has said 2020 judgment, my lord. And in 1983, Supreme Court has said, my lord, injustice in silence. The phrase used by the Supreme Court, if you don't publish the final answer key, it is injustice in silence. I'll read para 15. If you're,
Which is the citation? Can you just make a?
yes, yes, my lord. It says, my lord, in all the judgment 1983 4 SCC 309, Kanpur University through Vice Chancellor and others, Samir Gupta. You know, this judgment is followed in all the judgments of Supreme Court, subsequent judgment. Para 15. The findings of the High Court raise a question of great importance to the student community. Normally, one would be inclined to the view, especially if one has been a paper setter. Lordship, Scott.
No, he has given some.
Oh, Lordship, I'm sorry. My lord, I'm sorry. Lord, I never thought that I'll have to cite the judgment since there was a direction from your lordships to bring the answer key. But I'll just read slowly. Lordship will kindly appreciate. Somehow I failed to give this judgment, my lord. It subsequent I have given, my lord.
No, all right, Mr. Mahanta, you have a look at the matter.
My lord.
We'll post it tomorrow. And you will keep the answer key you have produced in seal cover. Will be kept in the record in seal cover. You put it in seal
Yes,
cover.
yes, definitely.
But this court is unable to accept this stand of the APSC that no, it's a prelims answer sheet. We will give it only after the mains is over and the exam is over. Very difficult to accept that. Maybe we have to write out a judgment if that is not covered under the Supreme Court. Because that part of transparency you have to maintain, my lord. That is for the sanctity of the examination process. Otherwise, even if there is something seriously wrong, after the mains is held and the final results are declared, how can these people seek remedy? They will be remediless. They will be completely remediless.
And in my humble submission, I believe that there is something wrong because Lordship will say,
Can you lordship give me 5 minute time, my lord? I'll take the instruction on that point. Yes, I also.
Don't rush into these things. 5 minutes, no, we'll give
Yes,
you more
my
than
lord.
that.
Yes, we can.
But
Yes.
publish the answers.
Yes, yes. We can.
Do it tomorrow.
Do
it tomorrow.
Tomorrow I'll place the.
Do it tomorrow.
My lord.
We'll have the
My
matter
lord.
on Thursday.
My lord, I also think for them, my lord. I try to, my lord, try to help the
I-
court,
my lord,
but your
I have
lordship kindly.
deepest respect for my senior, my lord.
My
But the
lord,
thing is that
that's
the
why my
stand
lord,
of
very
APSC
from
was-
other, I am, for their benefit, my lord, other matter I take examination. Yes, these are very important, is a,
Then Mr. Pathak's case also gets
No.
a lease of life.
then he
Though I
will
have
get
dic-
everything.
though
No,
I have dictated the judgment.
My lord,
Maybe
I also
I'll-
believe that regarding the OMR, my lord, decision, I did not want to interrupt your lordships, my lord. I would have perhaps, my lord, make some submission with regard to, my lord, furnishing of the copies of OMR or not. Because perhaps lordship would like to recall that order and keep it for fresh consideration. My lord. My humble prayer.
All
before
right,
your
then
lordship.
No, if-
why should we have a different standard for Mr. Pathak's case?
regarding, so far is regarding my lord, answer key is concerned. OMR sheet will be little difficult because out of
I'll-
25, that is my lord, that is very, because it is now.
No,
and
OMR
no,
sheet
nothing-
is a
Yes.
different matter. OMR sheet is a different matter.
Answer key, final answer key, yes.
Answer key, because
My
they
lord.
have a right to know what is
I,
gone
I,
wrong.
I understand it. My lord,
And
I'll,
unless they're given that option, how can they come up with a writ petition?
exactly, my lord.
What is the allegation they'll make? They can't make an allegation.
My lord, they are deliberately keeping this answer key under cover because in 2019, 90
So, Mr.
questions-
Pathak, that order doesn't go today. All I'll say is, we are posting these matters on 19th,
My lord.
right? 19th?
Lordship, 19. Yes.
Friday, no problem.
Thursday.
All right. And by Wednesday, you publish the final answer key.
My lord.
You want to obtain instruction or you can do,
Take up on, if otherwise not convenient on 17 or 18, my lord.
My
If
lord,
otherwise not convenient.
Not on record, we'll publish it, my lord, on before that, my lord. Your lordship placed it on 19, my lord.
all right. You write heard learned counsel for the parties in this petition. You tell Govinda not to type out that order. Huh? Give their names, so and so, so and so. In terms of the order dated 10/5/2023 passed by this court in WPC number 2384 of 2023, Mr. T.J. Mohanto, learned senior counsel appearing for the APSC authorities, has produced the final answer key in a seal cover. The same is taken on record. The court officer, the court master is directed to preserve it in safe custody. Replying to the query as to whether the final answer key can be published by the APSC in the official website, Mr. Mohanto seeks posting of these matters again on 18/5/2023 as fixed items so as to do the needful. It is made clear that pendency of these read petitions shall not be a bar for the APSC authorities to publish the final answer key of the CC.
GS1 and GS2, CC prelim.
CC bracket prelim, bracket close, examination 2022 in respect of GS1 and GS2 papers, right? Let us see what happens.
Yes, my lord. So, of the record, my lord, that High Court rule has to be followed, my lord, because it is very difficult for us to answer.
There is nothing to be off the record or on the record here. You see, as judges, we have to balance the interest of the society. As
Exactly, my lord.
Now, they are young counsels. They probably did not foresee some of the repercussions, but at the same time, when you are completely in iron screen, under a screen, under an iron, shield. However, these people have a gut feeling that something is wrong. Maybe their gut feeling is right, maybe it is wrong. But they are not being able to give vent to their feeling because you are completely choking them with the information. So that is what the problem is here. If the answer key was there, maybe this read petition would not have been filed, or maybe 50 more would have been filed.
Actually, my lord, we have not denied anyone. We have not denied. Actually, what is their answer? They verbally they were informed also. They mention in the My lord, all right.
And in any case, heavens will not fall if you find that some students have been wrongly given marks. Heavens will not fall. After all, they're young people who are seeking career option. What is the big deal? So these things can be worked out. But the reason why technically they have not been able to make out a case is also because of the fact that you have choked them with the information. You have not given them the right info, the information they are hungry for. They want to know what is the answer. You are saying we know, but we'll tell you after everything is over. Now, this is a difficult answer to accept. So how can in these circumstances court how can it be completely hyper technical? They could have argued this, they have not done it. He has touched upon it. But we have to be fair. Therefore, let us see. Once the answer key is published, maybe they will not pursue this matter. And you have already indicated the cases where there is technical defect, even if they score 100%, it is meaningless. Those petitioners do not have any chance here. Only out of those who have otherwise everything in place, but has been wrongly given lesser mark, their case could be live. And we'll see what is the remedy that can be given to them if it is established on the basis of then materials on record. Otherwise, even that fails. But it is true that in today's context, these are coveted jobs. People are working hours and hours, days after days, month after month, preparing for these exams. They will not take failure easily if it comes in a packet of non-transparent transaction. They want to have complete transparency and be satisfied that they have not been good enough. This is a reality with which every institution will now have to deal with and come to terms with. Otherwise, there will be huge resentment. I'm saying this because I request you to make your
definitely. I can give an example. A candidate came to me. He came to me, Milord, and then subsequently, after 3 days persuasion to the APSC, somehow in the APSC office, somehow he could come to know that he just forgot to bubble. Prior to that, 4 times he appeared in APSC examination, Milord, because it is because of the nervousness of everything. silly mistakes can happen. He said, I'll not file. It's
No,
fine.
that's
my lord. That
correct.
is-
That's correct. You
So
see,
that is also,
once the candidates are satisfied that
they
no,
will never come
they
for a
are to be
litigation.
blamed. Because these people are working hard. They prepare for months together. They make sacrifices. They have their mind set out.
Absolutely.
So unless they have satisfying answers, they will not be giving up. And that's not a good thing. To that extent, the court will support.
My lord.
That to that extent will support. But yes, after knowing this, Mr. Pathak didn't want to withdraw. Then the court had no option but to dismiss it. Because he came to know that these petitions are technically barred, but he still, and the problem is.
I think that if final answer is in published, he will get the relief also. He's
Yes, yes.
He's
Let us see
probably-
what happens.
My lord.
Let us see. All right. All right. Right.
Deep your lord. Much of it.
Keep it in your custody, safe custody. There is an order. Yes. Any other matter?
My lord, records have been called, my lord. Records have come, my lord. Records pertaining to my selection, my lord. And I have gone through, my lord. I have not found anything wrong there. And mostly whatever I have annexed in my read petition, those documents are there, my lord.
Yeah, finance has filed affidavit.
Finance says they have no comment to make.
Only two notifications were directed to be placed before this court. Lordship. Those two notifications I have received, Lordship. Lordship will see, kindly see at page. Page 23, Lordship.
That order dictated in the open court stands rescinded. Tell you. Yes. Where is the order of appointment? Order of appointment?
My lord. Page 28, my lord. Twenty-seven and 28.
And where is the order by which his services were terminated?
My lord, page 54.
So since 26th August 2021, he is out of service.
Yes.
You say you have no comment, but you are the department responsible for this.
Yes, Lord. Lordship will kindly say page 19, Lordship.
Hmm.
Lordship, this is OM dated 30th of March 2012, Lordship. I'm coming to page 20, Lordship, next page. Next page, Lordship. Lordship will see serial number 8 down below, Lordship. At serial number 7, Lordship, some instructions were issued how to fill up the post, grade 4 post, Lordship, without taking prior approval of the finance department. Next, Lordship, at serial number 8, sweeping and cleaning services are to be outsourced, and post of sweeper shall not be filled up in any department on any ground, including compassionate ground, except in government hospitals as per the stand of the government already submitted before the Honorable High Court, and the judgment issued thereon in WBC number so and so. Based on this stand, contravention thereof will entail personal liability of the concerned appointing authority.
Yes, but what happens to the post sanctioned by the governor?
Yes, Lordship, I am coming to that, Lordship. Then Lordship will see at page 23. Here your Lordship will see two districts are here, Lordship. I am Baksha somewhere here.
Yes.
Baksha. Sirang and Baksha. Lordship, we here at serial number, your Lordship will see one at in one table, serial number 15, in one table, another serial number 14, Lordship. Post of sweepers were permanently retained, Lordship. And Lordship will see at page 24, last two lines. Last two lines, the sanction is issued in terms of OM issued by the finance department by number so and so dated 3/7/2015 and so and so dated 4/9/2015. But Lordship, while doing so, Lordship, this was done by the Judicial Department, Lordship. And while doing so, Lordship, the notification, earlier notification, your Lordship, says 30th of March 2012 was not taken into account, Lordship.
So what has happened to these people who are in this?
Others are there, Lordship, only the post of sweeper. Other persons are there.
So therefore, now the petitioner is being made to suffer.
Yes, Lordship.
There is a communication gap between what is the solution to this?
Subsequently, judiciary, I mean the registry High Court, Lordship, they have accepted the stand of the finance department, and they would propose for redesignation of the post of sweeper as peon, Lordship. That was also rejected by the finance department.
Why that was rejected?
No such, Lordship will see page 52, Lordship. It's from Judicial Department to Registry, Lordship. In inviting reference to the subject mentioned above, I am directed to inform you that Finance Department by letter number 23/7/2020 has informed this department that there is no such provision in Finance Department to redesignate the post of sweeper.
Why should Finance Department redesignate? Who has given this advice? Finance department's job is not to redesignate posts.
Yes.
This is for the administrative department.
There was never an advice by High Court to, for re-designation. It came from Judicial Department.
All right, but why was it sent to finance department?
It was sent.
Mr. Das, I think the High Court should pursue this matter in the right channel.
So far as re-designation is concerned, my lord, in my affidavit, I have stated there are.
Do you have the judgment, Mr. Khan, that once the recruitment is made to a sanctioned post by following the prescription of law? What is this judgment about?
My lord, this is state of Uttar Pradesh versus Principal Abhay Nandan Inter College and others, my lord. Here also, my lord. Kindly, for the facts, my lord, para 9, 11 and 12.
What is the law? Let us see.
The law, my lord, para 54, relief. Para 54 and para 58, Roman 1 and 2. Okay.
So what is the solution here?
Whatever I have understood, Lord, in my understanding, after the 2012 notification, the post of sweeper is non-existing.
No, that's wrong understanding. But something more to that. First of all they said is don't recruit sweepers. The post has not been abolished. This instruction on the finance does not say that the post created by the governor cannot be abolished by the finance commissioner.
No.
Mr. Nayak, let's be very clear.
In 2015, Lordship, another notification was issued by the finance department. Wherein it was instructed to the departments that posts which are lying vacant and posts which are temporarily retained post, Lordship, that may be permanently retained by the administrative department without taking approval from the finance department. Lordship, while doing so, Lordship, this notification of 2012 was not taken into account, Lordship. And this
No,
notification.
that is correct. That is correct. But has the post of sweeper been abolished?
Lordship, once the decision has been taken that in this post, no person shall be appointed permanently, then Lordship, definitely only one conclusion is there that posts are no longer there.
That is very difficult.
Mail assist to lordship with operator on 1 point below.
We'll hear the matters again Thursday. You please develop your arguments.
What I feel is that, my lord, subject to my lord, it's not with regard to as I am appearing for the other side or not, as an officer of the court, what my understanding is that, my lord, this is a sanctioned post by the government, my lord. That post is given to the judiciary. There is a office memorandum issued that I have annexed, my lord. That so far as grade 3, grade 4.
So list again on Thursday as next item.
So far as grade 3, grade 4 is concerned, there is no requirement of taking prior sanction of the finance department. That OM is there. So perhaps the district judiciary, in view of that, since the posts are there, they have issued the advertisement and there is no illegality in the process of recruitment, my lord. Perhaps, my lord, since there is a OM.
So how do you reconcile the situation?
No, there is no situation. Only thing the finance can say is that our approval has not been taken in filling up of the post. The district judge also in his point is right because there is a sanction post and there is a relaxation given by the OM that there is no requirement for taking approval.
So where is the relevant memorandum rule or whatever you say saying that if you make an appointment and don't take our approval, then the appointment will be bad. Is that SIU approval? What is the sanctity of that? Is there any notification
Yes,
to that?
it say, there is a notification, it says for grade 3, grade 4 post, there is no requirement of SIU approval.
That is subsequent notification.
Whatever may be, my lord.
That is
That is there on
2015.
record.
It is there on record in my affidavit, 2015 notification.
And it has been done, my lord, as per the OM dated 3/7/2015, which reads, my lord, all posts created with the prior concurrence of Finance Department and Planning and
All
Development.
right, let me apply my mind Thursday.
My lord, lordship.
Or you can have it on Friday. If you, Friday is fine. Friday,
As per the
Friday is
Pick
fine.
up this matter after 2 weeks, lordship. In the meantime, I will take instruction, lordship.
Again?
Figure the status of the post.
Why the Friday?
What
Status of
happened-
the post is not abolished.
That is what I'm trying to, I will try to obtain instruction.
Friday will have it. You do it because I've heard this matter once or twice. Let me finish off. These cases should be finished off one after another. No? We have to go on with other. You can find out something Friday, put Friday's date. By Friday, you come up with something, but the issue will be that it is a sanction. Once a post is sanctioned, then it carries with him, with the post, a pay scale and other conditions of service. Then the question would be, is the recruitment made to the post by following the requirement of rules? If these two things are done in accordance with the rule, merely because the finance department says we don't want sweepers to be recruited, that cannot override the creation of the post. And to that extent, the right conferred on the petitioner due to his recruitment against a sanctioned post cannot be taken away by a supervening order of the finance department. If you can develop an argument in that line, come up with some decisions and see. Otherwise, it will have a disastrous consequence. But if the post itself is not sanctioned, then the matter will be totally different. Or it has been abolished, and after that the recruitment has been made, then it is a matter of law.
It is
Somebody
the
saying,
fate
I
of-
don't know.
It is the fate of that one person in the process. The fate of that person in the process of recruitment, my lord. He has tremendous faith in this process of recruitment after selection, appointment.
That's correct.
Then
Develop your